Victim of listing and bail application lordships on Monday lordships. Agent custody lordships.
Motion.
Motion lordships.
Motion 438, 439, all allowed. She will give the Monday,
Allowed.
Tuesday, yes.
Okay.
Please, sir. May I please, your lordship.
One female petition for motion.
Lordship, I would like to mention item 58.
Item
58.
yes.
LCB.
Yes, you want to mention, yes, what?
Item 58. My senior is out of station. Kindly matter may be fixed after 2 weeks.
My lord, a date may be given. I am for the petitioner, my lord. 50.
You are for
Respondent.
respondent NCB
After-
Yes.
After 1 week, my lord.
after a week on the prayer of the learned standing. Give a date. 20 on the prayer of standing council NCB.
My shop like.
May I please allow? But in item number 24 and 25,
Item number
24 and 25.
4 and 25. Yes,
That we have given a adjournment slip, my lord. So,
motion.
no, admission.
one.
4 is
24 and 25.
24 and 25. Yes,
We have given adjournment slip for adjournment. After.
okay. On the prayer of the any interim order?
Yes, in the both matter.
What are these?
Stay the further proceeding.
Huh? Further proceeding of what?
Further proceeding of the investigation.
No, investigation is.
Wait,
complete.
Wait,
Seated already.
already seated.
PRC case.
Huh?
Charge sheet.
PRC case.
Try charge sheet.
So trial is state.
Someone issues, no? Someone issues, not
Charge is-
appearance.
On the prayer of the learned council for the petitioner, matter stands. Who is for the respondent S. Ali K. Das? Have you taken consent?
They are not appearing lordship in last 2 weeks, two occasions.
Have you taken
And
consent?
we do not know his mobile.
Okay, call, not now. Yes, next.
To mention item number 50, my lord,
Item number?
50. We've withdrawn the petition to file afresh.
Well, in this case, my lord, I am appearing for the petitioner, my lord. We have not received any instruction from our client, my lord. If they have withdrawn this domestic violence.
Who are you?
We are the respondents in this case and they aggrieved in the main case. So it was handled by another council. And now that it has come to us, we have found a few lacunas which we are trying to.
No, you
make
want
by
to withdraw
withdrawing
what?
petition. The DV case, the domestic violence case.
Withdraw, dear.
Yeah, we have filed a petition.
That
So therefore,
order will be passed. How can we allow here to withdraw that petition?
no, just mentioning that since we have passed that, so this matter may be adjourned for the day.
Wait, we'll see. Yes.
Obliged.
Yes, you have the instruction.
No, my lord, I have just talked to our client, but they have not received any instruction my lord, regarding this, my lord.
Okay, then we'll adjourn it. You have instruction.
Okay.
It is submitted by MS A. Saikia, Learned Counsel for the respondent number 2, that the DV petition, the application filed under Domestic Violation Act pending before
The first class magistrate
first class magistrate of what?
of CGM Kamrup.
It's not that way. Yes, no, whenever it's called, you make a mention. Yes, next case.
May I please, your lordship? In item number 41, the state had filed and written objection that is not on record. Kindly, I may be allowed to call for it. They have filed it on 3rd itself. We have been served with a copy, but it is not tagged with the record.
Okay, we'll take up next week.
Lordship.
It is submitted that the objection filed by the state in the IA is not available on record. Full stop. Registry to verify and list this matter. Give a date next week.
41.
May
13th.
Obliged.
I pray for call for the additional affidavit, my lord, item number 59, my lord,
Item number
59. I have filed, my lord. Supplementary list.
You are informant.
No, my lord, we are for the petitioner, Mr. T K is there, my lord.
Yes.
My lord, my another submission is there, my lord, criminal petition number 238.
Hmm.
LCR has also come, my lord, as per your lordship's convenience, my lord, any date may be given.
No, we will not, we will repeat the prayer next week. All dates are fulfilled. Today, have you seen 68 meters?
My lord, my lord.
It
Obliged.
must be humanly possible. Yes.
May I please, Your Lordship? I beg to mention for a listing of an urgent matter, that is a criminal appeal against conviction. My lord, the delay has been condoned and IA for 389 has to be listed. It is a legal service
Appeal
matter.
not yet admitted.
No,
Conviction for how many years?
7 years.
7 years. Next Tuesday.
Obliged.
Yes, Mahajan.
May I please, Your Lordship, it was a listing, my lord,
Hmm.
for hearing, my lord, on next Thursday, my lord.
We'll make it listing for orders on next Thursday. We'll then fix a date for hearing.
Obliged. May I please, my lord? My lord, I prayed for listing upon criminal petition for motion, my lord. Tuesday, my lord.
Motion, yes.
Obliged.
Please, Your Lordship. Lordship, I beg to mention item 18, Your Lordship.
1-8.
It's in motion, Your Lordship. Criminal petition.
Yes. Yes, you want an adjournment?
Yes, Your Lordship.
Matter stands adjourned on the prayer of the learned counsel for the petitioner. List
1 week, Your Lordship.
after a week.
Obliged.
Bail granted. Yes, Munir.
I want to withdraw it.
Withdraw this, why?
No, sir, because of my fault, Lordship. That day I didn't notice, Lordship.
That is not an issue.
And thereafter, Lordship, mandatory period be over, Lordship, at that point
Okay,
of time.
okay, Mr. Munir, learned counsel for the petitioner submits that this matter has become infructuous. Full stop. Accordingly, present petition stands closed.
Much obliged.
One.
May it please, Your Lordship. My lord, there is an office note, my lord. It says that, my lord, service will be awaited, my lord, upon the respondent number 2.
Okay, steps upon the respondent number 2 was taken on 18/5/2024. Full stop. It is taken in terms of Deepakna,
Yes, yes.
Deepakna, in terms of the
Okay.
notification number 17 dated
And
15/3/2024.
obtain
Full
instruction.
stop. Huh?
And it can obtain instruction.
In that view of the Mr. B. Sharma, learned additional public prosecutor submits that he may be granted 3 days time to obtain instruction for the concerned of
Police station.
officer in charge of the police station or from the concerned police station as regard status of service of notice upon respondent number 2. Prayer is allowed. Please this matter on.
For vacation, my lord. Anything.
Yes, yes, of course. Next.
Highly obliged. May I please, my lord,
Art-
consider matter, my lord, notice will go to the informant. my lord.
Are Swenso. Application under Swenso. Scan copies of
LCR.
LCR of
Special just come to permit.
special case number 167/2023 pending before
Special just POXO, Kamrup Amin.
special judge Pokso Kamrup Amungao along with the case diary of Swalkusi PS case number 171/2023. Full stop. Notice be issued to respondent number 2 in terms of notification number 17 dated Swenso. Full stop. List this matter on.
My lord, kindly
Before
file
that,
vacation.
before vacation.
Before.
28.
My lord, Special POXO case number 167/23. 167/23. 67/23.
That is what we have said.
Highly.
My please, Your Lordship.
Yes.
379, Your Lordship. I am not the main accused, Your Lordship.
FIR is page number 7, Your Lordship.
How many days?
Another 15 days, Your Lordship. Another co-accused already released, Your Lordship, is 15 days. Some other accused person caught red-handed, Your Lordship, some perfume article and were recovered, Your Lordship. I am mechanic, Your Lordship.
Yes, Sama. With a satisfaction of
CGM Kamrup Metro.
CGM Kamrup Metro. Case diary. When? Some. Notice to respondent number two. In terms of sense.
26 looks.
26.
Much of that.
Same. Notice to the respondent number 2.
26 looks.
Dear my lord, one pen drive has been seized, my lord.
Hmm.
My only contention before a lordship, my lord, page 15, my lord, is my photograph along with the my lord, I-card, my lord. And let the PP have a look with the pen drive, my lord. My case is that I am not that person, my lord.
You are inside.
Yes, I'm inside.
So we are taking out it Tuesday, next Tuesday.
Yes, yes.
Huh?
Can I, not Tuesday, my lord, let it be on my lord Wednesday.
PP, when?
In the
It is from which place?
From Gorsup Lordship. We can have the
Gorsuk,
case
so
diary.
Wednesday?
The pen drive, he matches, my lord. I'll
Okay.
match.
Call for the case diary. The petitioner raises a dispute that the petitioner is not the person who is involved in the case, and he has been arrested due to mistaken identity.
Yes.
Full stop. The IO of the case shall apprise this court as regards that aforesaid contention while producing the case diary on the next.
Along with the pen drive, my lord.
Along with
That has been seized, my lord. That's
Okay.
why I'm saying. I'm objecting.
CD interim. Get-
Vacation. After vacation Lordship.
After vacation, 10 days you appear, get rest.
Maybe the Lord. 438 application, my lord. In this case, the complainant filed a complaint
The
against.
present application is filed under section 438 of the Code of Criminal Procedure 1973, seeking pre-arrest bail in apprehension that a case might have been registered on a complaint lodged by, what was the name? Huh?
Joymoti Kyor.
Joymoti Kurt, arising out of a financial dispute between the petitioner and the said Joymoti Kurt, full stop. It is specifically stated in the petition that the police is harassing the petitioner, and accordingly he has also lodged an affair. Considering the matter in entirety, let a report be called from, let a report be report be given from by the Hadgaon police station as regards pendency of any case lost by the said so and so against the petitioner. Full stop. Considering the nature, it is in the interim, it is provided that no coercive action shall be taken against the petitioner arising out of any complaint that might be filed by the aforesaid
Petitioner.
petitioner.
Krishna Kantona.
Huh?
Krishna Kantona.
No.
Joymoti Kyor.
Joymoti Kurt or on her
Inform.
behalf.
Next Friday.
Friday.
9.
May I please your lordship?
Yes.
438 lordship, FIR is a page number 17. Here, allegation is that signature is false and I have used the seal. But as per law, lordship, section 39.
CD interim.
Oblige, give me oblige.
Interim. Date give a date.
10.
Yeah, please, your lordship. Lordship, 438 application, lordship. FIR is at page 16. Lordship, we three have not been named in the FIR.
Hmm.
However, we have received 41 notice, lordship.
APR CD interim within 10 days.
May I please your lordship?
Case diary. No interim.
Lordship, he's not FIR name accused, your lordship, and he's the person owner of the vehicle, your lordship, who has been used for stolen. I engage basically a driver, your lordship, in the vehicle, your lordship. Kindly let me appear before the IO. I will disclose everything, your lordship.
What is your name?
Rafiqul, your lordship. His name is
We have
not there.
already some petitions, some FIR, this case diary I have gone through it. Give an early date,
Lordship, 27.
27.
Obliged, lordship.
Who is this Santanu Borkatu? Why he is apprehended?
I thought it's a anticipatory bail application. He is 67 years old.
His father,
Father,
CD interim.
and division bench for review has been dismissed, withdrawn.
May I please, your lordship. Lordship, this is a 438 bail, anticipatory bail application. It's a charge sheeted matter, and the next date before the court below is on 10th of June.
This is item number?
Supplementary 56. Your lordship,
Where is the FIR?
the FIR is at page number 11, your lordship. It's a charge sheeted matter, your lordship. The crux of the matter is that your FIR was launched 50 days after the cause of action, after the occurrence date of occurrence. And subsequently, when the FIR was registered in the charge sheet, also the police has accepted that I was outside the country at that time, your lordship. Get the date of the FIR as well as the date of the charge sheet, your lordship. On both dates, I was out of the country, your lordship.
Where is the summon?
Indeed, your lordship, summons I have not received as of now, the police summons. After the police have started to search me again, it came to my knowledge that the matter has been charge sheeted and it is in the appearance stage before the court below.
So apply that copy.
Indeed, your lordship, the person came from Saudi Arabia on 5th of June, today is 7th of June, your lordship, due to the paucity of time, and he is willing to appear before the court on 10th of June, your lordship. We are willing to face trial and all the sections available except one section 376, which is no material as per the FIR charge sheet also, your lordship.
Lordship, kindly come to the charge sheet, which is at page 23, Lordship will find. Down below, Lordship, big facts of the case.
20?
23. Down below, Lordship will find the brief facts of the case. Lordship will count to 6 line, Lordship. On 15/2/23, 10 PM. The FIR name accused Tahirul Islam.
Your
It's
lordship,
clearly stated, Lordship, in the next page also that he left for Saudi Arabia
indeed, your lordship.
in the later part of the February, Lordship. Whereas the incident is of first part of
Yes.
February, Lordship.
The date of FIR is when he was all not in the country, your lordship. After 51 days, they filed the FIR. Moreover, your lordship, at the time of registering the FIR, section 67A of the IT Act was attracted, which the police itself dropped in the charge sheet, your lordship, due to unavailability of any materials.
Only the scan copy, Lordship, at this time.
And I'm willing to appear before the
Ah.
court below, your lordship, on Monday.
Mr. Swenso. The present application is filed. Under section 438 of the Code of Criminal Procedure 1973, praying for grant of pre-arrest bail to the petitioner in connection with PRC case number 977/2023, registered under 2073. Full stop. The aforesaid police, the investigation to the aforesaid police station case. Police station case to Belega, Murajar seeking PRC case number full stop. And one FIR was lodged in Murajar PS station, police station, which was registered as Murajar PS case number 100 of 2023 under section 448 slash 376 slash 500 read with section 67 within bracket capital A of IP Act, full stop, Act wherein the petitioner is named as the prime accused, full stop. It is the case of the petitioner that he was out of the country on not only on the date of incident, but at the time of filing of
Lordship, at the date of the FIR.
on the lodging of the date of the FIR, as well as on the date of filing of the charge sheet, and therefore he has been shown as absconder. Absconder, full stop. He further contends that the petitioner is willing to participate in the trial. However, he may be protected. However, he apprehends arrest, full stop. This court, to ascertain the contention of the petitioner, shall require to go through the case diary of Murajar PS case number 100 of 2023, as well as record of PRC case number 977 2023, pending before the learned Chief Judicial Magistrate Hosai. Accordingly, call registry to call for the scan copies of PRC case number 977/2023, along with the case diary of Murajar PS case number, along with scan copies of scan copies of the case diary of Murajar PS case number 100 of 2023. Full stop. List this matter on
Last part of this month, Lordship.
Give it-
27 or 20.
27th. 27th of June 2024. In the interim, it is provided that no coercive action shall be taken against them.
Much obliged.
Wait, please, your lordship. Lordship, this petition regarding Jima of the vehicle, lordship, order, lordship will find on page 29, lordship.
Where is the offenses? Offenses under?
It is on FIR on page 18, lordship. The vehicle which was stolen, lordship, it is AS01FC 7935. But my vehicle, lordship, seizure, lordship will find on page 23, lordship. Relevant portion on 24, lordship. Description number 8, lordship. They have seized my vehicle, lordship, and registration
So according, who lost the FIR?
FIR, lordship, it is lost by Abizur Rahman, lordship.
Page 18.
Page 18, lordship.
So it was a case of vehicle theft.
That by some other person, that is their name is there in the FIR, lordship.
Hmm.
But I am not the named FIR person, lordship.
You are the owner of the vehicle.
Yes,
How
lordship.
can you be named as a?
But lordship, they have said, lordship, the ground of arrest, seizure, lordship. The rejection order, lordship, it is reflect on page 29, lordship.
Hard. We'll call for a report.
One report should be.
Hard, Mr. Islam. Or Islam. Beach. Oh, sorry. Beach Chaudhary, Learned Council for Petitioner. Also heard Mr. Also heard Mr. B. Sorry. Das Learned Council for the Additional Public Prosecutor. The present application is filed so and so, silo. This court under its order dated 15/5/2024 call for the case record, scan copies of the case record, full stop. Same is not received, full stop. Registry to issue reminder. Already seated.
No, lordship, it is not charge sheeted, lordship. Item number, lordship, 13, lordship.
Salman Dewan.
Salma Devan.
Why damn records were called for? Anyway, full stop. Call for the case diary as well as a report.
Only report.
Of report. Call for a report from the IO of so-and-so police station case in as regards the Jimma, as regards granting of Jimma of the vehicle to the petitioner who claims to be the registered owner of the vehicle. List this matter on
20 June 20.
20.
Highly obliged.
Yes,
Item 14, Lords.
yes.
This is a criminal revision petition arising out of order from DV Act of the judicial magistrate. Lordship, in this matter, notice could not be served upon the state, also been made party. So time may be allotted for serving notice on state and also private responding.
Private respondent,
As friends of it.
so you are issuing a notice?
আমার copy আছে দেখুন।
No, I think their system is something different. So, hard, you are Mr.?
ML Pandya.
You are an outstation counsel? Yeah.
It was served, but for some reason in the registry could not be that be submitted, I think.
No, hard, Mr. Panda, learned counsel for the petitioner. This is a petition assailing an order dated, order dated 5/6/2021, passed in miscase number 1 of 2020 by the learned JMFC Kamrup within bracket Metro. Full stop. Issue notice returnable on.
Petition আছে?
19th of July.
What is this then?
19th of July 2024. Mr. Das, learned counsel, accepts notice on behalf of the state. Mr. Das accepts notice on behalf of respondent number? Respondent number 1. Full stop. Petitioner to take steps for issuance of notice upon respondent number 2 through registered court as well as it.
May I please, your lordship,
Yes.
my lord? Perhaps, my lord, my lordship has already heard once, my lord, we have been allowed to withdraw. And thereafter we have filed.
Will allow this petition,
My lord.
subject to two conditions. We have already heard there is a defect, so we have allowed to withdraw. And to refile afresh. So far relating to the two mobile phones, if anything is to be retrieved, they will do it and hand it over.
Oblige.
We'll get the order Monday only. Dispose of.
Your lordship, lordship is a revision against concurrent finding, my lord. My lord, here, my lord, I have challenged the order, my lord, with revision with regard to the finding of the honorable, honorable court, which upheld the conviction and the impose of the additional season, my
Why
lord.
should you exercise your revisional jurisdiction? What is the glaring illegality?
My lord, here, in the complaint petition, as well as, my lord, in the evidence on affidavit filed by the complainant, has not stated on the date on which it has been given, my lord, whether it is a legally enforceable debt or not. Secondly, my lord, the most important part is that exhibit 1, the 6, that was not proof, my lord. My lord, that was also out of, when I have seen the annexure, my lord, it has been clearly said it is not been proof, my lord.
Next week. We are not convinced of this petition.
I have the annexure in this
If you
annexure,
want to proceed, you can proceed.
my lord. My lord,
Yes. Absolute concur and both sides. We have little scarcity of time today,
my lord,
and otherwise you can dictate it right now,
then next week, my lord.
next week on the prayer plan. Heard Mr. T. Deori, learned counsel for the petitioner. Also heard Mr. D. Das, learned counsel, learned additional public prosecutor. For, is it a party state? Yes, respondent number 1. Full stop. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing complaint case being CR case number 7490/2020 pending before the Court of Learned Chief Judicial Magistrate First Class Kamrup Metro Guwahati. Under section 403, 406, 420/34 IPC. Full stop. Issue notice returnable on after vacation. 19th of July 2024. Mr. Das accepts notice on behalf of the respondent number 1 petitioner to take steps for issuance of notice upon restaurant number 2 with registered post as well as to usual process. First of, peruse the complaint petition as well as, where is the statement? No statement. Peruse the complaint petition.
Annexers, your lordship.
Ah.
Annexer 41, page 41 and 44, your lordship.
Where is the initial deposition?
One second.
I'm not annex the initial deposition.
Huh?
Next one.
Annex, not annex the initial.
It's
The
title,
complaint is there.
Mr. Deori.
Complaint is there, your lordship.
Complaint is there, but we need to see the cognizance is taken not only on the complaint.
The basis of taking cognizance.
Then what is the provision of that recording of statement on the tone? On the prayer of Mr. Deori release this matter next week. First of he may file an additional affidavit bring on record the statement of the witnesses recorded under 200 CRPC. Tuesday next. No, we have to adjourn it.
Madam.
We want the lawyers to be careful.
Notice.
Yes.
No, notice. Adjourn. It's adjourn, your lordship.
Adjourn.
Complete, your lordship.
May it please lordship.
Yes.
Lordship, it is a mercy petition, lordship.
We are not here to do mercy.
Officer in charge of Hazu police station, I was called for as a witness, lordship. Page number 8, lordship.
We are dismissing this petition. For people like you, trials are being delayed.
I will appear, lordship. Apology,
You appear, we are not passing.
I-
You want a dismissal, you can dismiss it, giving certain examples. And we'll also, after dismissal, we'll take it with another matter, which we are monitoring, to show the state this example.
Only once a person,
No.
lordship. I will appear.
No. This case I will not pass any.
Some opportunity may be given, lordship, then today,
No, there must be
Today-
sanctity of the
What-
everything.
or at today, adjourn the matter, lordship, then I will get over because lordship, I will discuss, lordship, because lordship is official which has.
If you pray adjournment, we will not say anything, but you want an adjournment?
Adjournment, lordship.
Learned counsel for
From
the
Monday,
petitioner prays for an adjournment, prayer is allowed. This matter after 2 weeks.
Lordship, 14 dates is fixed, lordship. Lordship,
Then why are you taking the anxiety? You will pass the order.
is going to
You will
dismiss.
be over, all anxieties will be over.
Lordship is going to.
The moment we
dismiss.
dismiss, there is no question of 14 or 15.
Lordship, kindly allow me to appear.
No, it's not question of the law.
Lordship, only today for lordship.
Today for what? You want it to do it Monday?
Monday.
Monday.
Item 20.
Mr. Bora,
My lord.
we'll take after the bails are over. Not so confident. Because it's if we proceed, we'll have to stay. If we say then you don't have, we dismiss it. And if you can convince us that it's a case of notice and stay, then we'll pass that order.
Yes, it's a case of a notice, my lord. The prejudice has been caused to.
We'll see. We want a delivery, sir, not straight away.
Right.
After the bail hearing. matter.
First.
Yes, Amen.
439 application lordship. Petitioner is in custody since 10/5/2023. Here, lordship will find the FIR at page 13. Petitioner is the driver, lordship, and some paneer were transported. There were e-way bills that your lordship will find in the FIR itself.
Transported what?
Paneer.
Paneer.
Carton
Then what?
of Paneer was there, and subsequently one person
Yes, there are
came
no
and
bill.
he also claimed some of the paneers, lordship, and he disclaimed the other part. But e-way bill was there for entire package.
Now, who are you?
I am the driver of the vehicle.
Charge sheeted.
Charge-sheeted. I was under the impression that paneer is transported. Paneer was written in the e-way bill also. That your lordship will find page 15. The
Now,
other
what is the
person,
offense?
Under commercial.
379.
No, so NDPS.
33,000 my lord
22C.
bottles are there behind paneer my
Oh, acha. I thought there is a simple paneer.
lord.
What is your allegation against you?
Page 13 is the FIR.
Will it not be a conscious possession?
Conscious possession, that is lordship, that Madan Lal will come, Mohan Lal. So possession with animals, that I have, that knowledge has to be there.
No, that is there, but at the stage of bail.
That from the FIR itself, it is apparent, lordship. Being driver, lordship, e-way bill were there, the paneer were there. He was transporting.
And
paneer.
who are are the accused persons?
Other also the
All the
driver.
driver,
Then the
co-driver,
investing,
helper,
lordship.
everyone.
And who sent it? Have you expanded your inquiry to that?
He was under very well, lordship. Just I'm placing this.
He's an accused in the search sheet?
No.
Not today, Monday. Tuesday.
Public.
Do they say that these e-way bills are fake or fraudulent?
Even they said in the FIR itself, they said they seized, but in the charge sheet, they have not sent those e-way bills. Reason based no.
E-way bills might be there, my lord. Because in the name
No,
of
we
my
want
lord-
to see in the case diary.
Yes,
Okay, they might have a conscious possession
yes,
because being the driver, they must aware of what
yes,
is what.
everything is,
Suppose it is a packaged food. Just assuming that may not be a subject matter at the stage of bail.
yes,
But if these are e-way bills, manufacturer is disclosed, destination is disclosed, then how will you establish a case against them? Until and unless you say that these are fake documents, in fact, this person is non-existent. We'll see this.
there might be, my lord, there may not be a fake documents, my lord.
Then,
My lord, what about the?
then you'll have to say that
possession?
these
What were the
were
possessions?
unsealed, then thereafter it was inserted,
it's-
anything on that record.
I'll see.
See, we are not giving
No, sir.
them that they are not involved. But if you do the
And also CP will
investigation in this way, and apparently those who are having suspicion will see that,
Yes.
then we'll consider. You take those portions, go through the record. Okay. Mr. MP Goswami, learned counsel for the petitioner, press for an adjournment to go through the scan copies of the record. Full stop. Prayer is allowed. Mr. Ahmed, learned counsel for the petitioner, may also go through the same.
On Monday, Tuesday, lordship,
Tuesday,
14.
20. This is item number.
39 application, lordship.
Hmm.
It's under section 6 of Box Act is there, lordship. There is one difficulty, lordship, service is not completed as per.
Today morning also, lordship, I tried to inquire, lordship, we have not received any reports if service has been completed or not, lordship.
Can it be fixed on, lordship, next 14, lordship? 14.
14th. List this matter on 14th. Full stop. In the meantime, the Mr. B. Sharma, learned additional public prosecutor, shall obtain status of service of notice upon the informant slash victim. Informant slash victim. Full stop.
Most of.
28.
May I please, Lord?
Yes.
Only the allegation is under section 21B, manner, NDPS, manner. Petitioner the husband wife. Petitioners are the husband and wife. Husband found a suspected heroine found in the tea stall in front of the Ram Mandir. And thereafter, the husband took to the house and wife also arrested on the same date when the Azhar was lost. Azhar lost.
Now,
by the
who are before us?
Nurul,
Both husband and wife?
yes.
husband and wife.
Lordship will kindly come to the forwarding at page 16. So we'll find,
Yes, there is there.
yes, Lord. heroin 12.15 grams from their possession, and Lordship will pay attention to grounds of arrest, ground number 4, Lordship. That is reflected in the case diary as well, Lordship.
Now, what about the lady?
He is also involved, Lordship.
Involved. How many days?
48 days behind the bar.
It's quantity is commercial quantity.
Intermediate.
Intermediate.
60 days.
And
FHL not received, Lordship. Recommendation 48. Instruction available. Service of
heard. Mr.
Islam.
B. Islam, learned counsel for the petitioner, also heard Mr. B. Sharma, learned citizen in public suit. Petition application under section 439 CRPC. Switch. The two petitioners were arrested on which was the date?
21/4/2014.
Peruse the material available on the case diary, including the statement of the witnesses who witnessed the seizure. Full stop. From the material available on record, the material available on record suggests that the contraband was seized from the possession of the petitioner number 1 or 2? One. Petitioner number 1. Full stop. It is also suggest that the petitioner number 2, while petitioner number 2 fled away from the place of occurrence. Full stop. The material further suggests that the accused number 1 is earlier was also involved in similar cases earlier. Full stop. However, the material also discloses that the wife, the petitioner number 2, who is wife of the petitioner number 1, nothing has been recovered. Also says that nothing has been recovered from the wife of the petitioner number 2, wife of the petitioner number 1. Full stop. In as much as the she was arrested from her residence and nothing was recovered from her residence also. Full stop. Considering the nature of allegations and material available on record, this court is of the view that there are sufficient incriminating material against the petitioner number 1. Accordingly, the bail application, prayer of bail made by the petitioner number 1 stands rejected. However, considering the material available and so far collected by the IO, no further custodial interrogation of the petitioner number 2 may be necessary. Accordingly, our prayer of bail stands allowed with the following conditions. Yes, there will be returned law. To the satisfaction of Special Judge NDPS. Special Judge NDPS Morigaon.
29.
May I please, your lordship, kindly matter will be passed over for the time being.
29. Charge submitted, liberty. You approach the
CS number 218/24 dated 31/5/24.
dispose of. Yes.
Lordship, I have been languishing in jail for 539 days till today. And I would like to take the ground of inordinate delay made by the prosecution. And last witness was examined on 14th of December 2023. And later on, no witnesses examined today. And total 6 witnesses and 2 witnesses have been examined.
Who are you, a driver?
No, Lordship.
Truck
Passenger, Lordship.
from his position.
Yes, but 4 persons are involved, Lordship. All of them.
I was the handyman.
Handyman.
Police searched the truck. They were the driver and handyman.
Yes. Also, already 2 PWs has been examined out of 6. 2 more.
That is what I have seen.
2 more seizure witnesses are there, Lordship. At least. That's 2, Lordship.
On the prayer of the learned counsel for the petitioner, release this matter after 2 weeks. Yes, next.
Public.
Kuntu.
Yes. Lordship will find the FIR my lord, in my additional affidavit filed on 5/6/2024, my lord, track X.
You have not been arrested.
Oh, as my lord, not arrested, my lord.
Still not arrested.
Prime accused has been arrested, my lord.
Who are you?
1 person arrested, man.
One arrested. Who?
Accused number 2.
I'm 1 and 3, my lord. May I read the FIR, my lord? সন্মানপূৰ্বক বিনীত নিবেদন এই যে উক্ত দ্বিতীয় পদকীয়াজনে মোক কস্তুৰী বা বালিকা
Your friend for some time, then come to us. That will be a better proposition. Be with your friends for some day and then come back to us. Your friends are there.
One friend is there, my lord.
One is ask the other also. Then go there and come back.
Can it be fixed on 18, my lord? The another matter is
Okay,
fixed.
18th.
That will be better, my lord.
Okay, that will be better. It is submitted by Mr. TK. We are learned counsel for the petitioner that one co-accused has already been arrested and bail application filed by the said co-accused is fixed on 18th of this month. full stop. Accordingly, he praised that this application may also be fixed on that day. Prayer is allowed. List this matter on 18th. Along with,
I will give you a number of this.
keep the CD so that on 18th, all French fate will be decided. Yes.
May it be so, Lordship.
Yes, where is the FIR?
FIR is present.
61 also arising out of the same.
61.
Present.
What is Bangladesh?
Yes.
Bike sending to Bangladesh.
Yes.
Tafiqul Rahman.
And what is your case?
Page 17.
Car workshop.
What do you do?
One of the code views, he happens to say that he has given me numbers of the line.
These are BA or AB?
BA.
This is BA. How many days?
35
And him?
37.
What is the stage of investigation?
Investigation is still going on, not succeeded, and
We have already gathered that these are being sent to Bangladesh. Some of the bike Bangladesh.
They have, one of them, two of them have confessed that earlier hundreds of bikes they have sent to any dealer, and they are picking up bikes not from Nongpu area and other from Assam also.
But this is, they are not stealing bikes. They are, what they are doing is they are having brand new bikes. This is the new modus operandi.
So far I am concerned, I am being a garage, these bikes might have come up for some mechanical.
No, not mechanical. They require something more. Because
Engine
bikes.
and chassis maybe.
And these bikes are not required. Not the frame, but the engine.
60 days happens, otherwise.
That the bike engine that helps you to run those motorboats in Bangladesh.
And engine and chassis, if
That
this
is not
engine
required. Engine chassis, nothing is required. Might be you are part of that. Engine is required to run ferry in Bangladesh.
Bikes were handed over to one person at Nagaon. I don't know who in fact has done it. But
It's collective. These person earlier 2-3 persons are there.
No, they are involved, but that is sure. I have seen the case there. In some other cases.
But
Similar,
my
but
prayer is that 60 days offense, let some.
Already completed, and they have also living children also. I mean,
Don't
alpha
show
family
papers.
birth certificate.
And how many days you are behind?
37 days.
So according to them, at least 40 days or 45 days will be better.
Some more days.
The basis of the allegation. The informant. He agreed that he was.
No, that is in this case, in fact, his allegation is that, see, my friend, he has taken my number, OTP created this, that, then bike was purchased in my name. Subsequently, I could not only this, other cases are also there.
And that's
Where
whole incident
two
comes to
ways.
light.
One way is that you will be given a job. Before that, you need an account. Otherwise, your salary will not be paid. You create an account, then take a loan. And the banks are very happy giving loan. They are not so much interested with the papers. More particularly small loans, bikes. Loans are given. The owner is not aware that loan is granted, bike is handed over, then bike is gone to Bangladesh. So this is a huge model. This is not the only case.
Here, so far, he is aware that the bank loan will be taken, EMI will be given by one receipt. And
no, that's correct. In that sense, there is no case is made out. In that sense, because this is a commercial dealing. But in the process, police discovered that this modus operandi leads to something else. And this is not the only case. There are other cases where these loans are, these laborers and some other petty workers, young boys, they are said that you will be given job, but now in terms of Union of India government, the notification, salary cash cannot be paid. So we need your account. For this, give your Aadhaar, this, that, and they will operate account, loans will be granted, bikes will reach Bangladesh.
And most of the bikes are Royal Enfield heavy bike. Yeah,
And all these are new bike without even registration number. So this needs some investigation further.
But page number 8 of the FIR, your lordship, namely one Tikanjit Boru has taken the documents from the informant, your lordship. As per basis.
What is your item?
60.
60.
Yes, lordship.
Okay.
420 and 406 IPC was registered by the police, your lordship. They have no any 379 or other sections, your lordship.
No.
So, lordship, Tikanjit Boru has taken the documents, and our name is not mentioned in this FIR, and we have already in custody 35 days in your lordship, and we have also little children also. May allow for submit the birth certificate, your lordship.
Oh, little children forget.
Yes, lordship.
You
Without
would
the
have-
accused person, they have to face
That
very
cannot be a
difficult,
ground.
your lordship.
Item 60 dismissed. Yes.
Yes, your lordship. I will lordship. There may be allowed in any condition.
Dismissed. And Mr. Sakya, you need an adjournment?
Shafiqul Rahman alias Babu.
140 days.
I am not saying
On Thursday.
on his malad,
Your case is on Thursday, her case is dismissed.
This is the same case, your lordship.
You are arguing, he says he sought an adjournment. When you are arguing, how can you grant you an adjournment?
Thursday may be.
He has sought for an adjournment.
Thursday may be taken up, your lordship.
Already you have passed the order. Thursday.
Send that, your lordship. Kindly.
At least 10 days, so that we can send the CD.
Let us have it on next Monday. Okay?
If something
This not this Monday, next Monday. Mr. Saikya, why I have seen this CD and similar CD. These offenses maybe she is arguing that this is 406. Okay, maybe in the FIR in the 406. If you are involved, who knows these are being sent to for terrorists without number plate and the routes are all those routes. Who knows? Further investigation is required. Next Monday.
18.
Not 18.
17 is holiday.
17 is holiday.
18.
So 18. 24.
24.
24.
You take back the CD and we'll on next that we'll grant them bail.
My lord.
If you want to do something, you do it.
Both
We'll
of
see. You see. Yours is dismissed already. Yes.
Lordship, my lord, this is the case where the amount of rupees 15,000 was given on loan to the my lord informant.
Where is the FIR?
By the petitioner, my lord. Page number, my lord, 14.
Oh, what happened?
Yeah, my lord.
Tell us the
Yes,
subsequent.
my lord. My lord, now, my lord, after the last occasion, my lord, the petitioner again approached the informant, my lord, to take back, to give him had 2 pairs of earrings, and my lord, to get back the loan amount. The informant will pay the loan amount. My lord, the advocate of the informant called me, my lord, last day and today morning also, that they are agreed to take back the amount, my lord, and give the loan amount, my lord. So, my lord, if the matter may be fixed on next Monday, my lord.
Yes,
I will
no problem.
I will file, my lord, this.
Otherwise, my lord, but this money is small.
How we have seen that?
Small amount.
Sometimes we
But
do
the small amount for that, those
Yes,
people
yes. Therefore, we have granted interim. Earlier, there is no interim. The interim is to facilitate this.
My lord, interim on the grant the past day.
Okay. When?
On Monday.
On the prayer of the learned counsel for the petitioner, matters stand adjourned and be listed on
12.
12th or 24th.
No, 24, my lord, CD is here.
So that's why you return. Can you return it back? You file an affidavit.
Maybe previous week, my lord, because
give
sure, my lord, it will become
okay, give it 19th. 19th.
Interim may be continued.
Interim order passer shall continue till.
This is a 430, they have appeared. To
Yes,
Mr.
for us, sir.
CD not received.
CD not received, interim to continue. When? After vacation or
After
what?
vacation.
Let us not create a havoc before vacation. Give a date after vacation. 17th.
My lords.
Oh, 30 plus, yeah. Well, same PS, second accused.
Same.
Oh, same.
Yes.
CD was called for.
Did you receive money?
Did you receive? What is the FR?
When FIR, it is the industrial property matter I got mutated after.
No, that will come to later on. Let us have the FR first.
Where is page 12 matter, kind of.
PS?
Page 12, Annex 1. It was addressed to Deputy Commissioner Dhubri. Matter relates that the Bilashi Pada matter.
Who are you, Samujjal?
Yes.
Huh?
Yes.
Yes, what is the material?
Well,
That gun and all.
mm,
Apparently civil dispute. He was
yes,
said
yes,
to
but-
be hired gun. I have some doubt.
Going on.
There are 4 independent witness villagers. They all said that the incident occurred at about 8 p.m. night. And they said that halla huna pao. Samujjale murat pistol ধৰিছিল বুলি শুনা পাইছো কিন্তু কোনো গুলি ফুটাৰ শব্দ শুনা নাই
This is an application under Swensu.
all are-
Peruse the material available on record. The investigation is at a very advanced stage. Full stop. The material so far collected, more particularly against the present petitioner, in the considered opinion of this court, shall not warrant custodial interrogation of the petitioner. Full stop. Inasmuch as petitioner, inasmuch as his statement can be recorded by the IO if an protection is granted. Full stop. Accordingly, the present petition stands allowed within 10 days. No hamper, no tempering.
Amount, bail amount.
Something will be there, 25. Disposal.
Lord, he appeared before the police authorities thrice, my lord. He appeared on 8/5/24, 9/5/24.
Where is the FIR?
Lord, we came against a complaint. Subsequently, FIR was lodged, my lord. That I have got a copy of the FIR. Lord, complaint page 16, my lord. Lord, it is pertaining to
Pertaining to?
Regarding altering the data in the system of GMDM, Lord.
What kind of data?
You know, this is with regard to the permission, building permission. The complainant says that the FAR details in the system of the GMDA that has been altered. You know, I am a architect firm. Lordship is aware that now architects are outsourced by the GMDA for permission. So after uploading, I am required to only upload the application of the client and thereafter my duty ends. Now, if some alteration has been made in the system, that is the Softtech Engineers Limited, one Mr. Obhijit Bhomik, he is the implementation head, and it is the Softtech which developed the system as well as they're running and maintaining the system. Now, it is beyond my reach. And the allegation is that my phone number was used. You know, my details are there with the GMDA because while registering ourselves, we have to give our details. And he is cooperating with the police authorities. You know, he has already thrice he has appeared before the police authorities and gave his statement.
Yes,
Matlab, his duty is to what the person applying for the building permission and all this, matlab, the total floor area, and he has to see that area can be given or not. The allegation is that he has given higher floor area by manipulation of some document. Now he has appeared, he stated that matlab, in some cases only when matlab, some old and new DUG number comes, when some applicant died and in place of his some other applied, in that case only he made some corrections. And he for some technical issue, he took the help of that one person, associate planner and from the matlab, software company. But regarding this, matlab, he has denied all this. This he is appearing, but police,
custodial interview.
Police stated that matlab, some doubt is still there matlab, regarding this. Softech Engineers Private Limited, that is the company who developed the.
We are not giving him absolute bail today. Let it continue for some time if you want to have some material.
Matlab, yes, he's already in interim, matlab.
Interim, already interim, because already statement is recorded. If you still say that no, at this stage there may be some material against him.
Police,
if that is the apprehension, instead of making it absolute today, we'll wait for some more time.
Or some police matlab, given bail objection because of that matlab.
Okay, let us see.
Because this type of matlab, offense matlab, we are also not. Whether he can actually matlab, done this or with the help of some other person or not.
System, my lord, I cannot, I have no access to the system.
We know that.
System is developed by
But
the
architect,
I am an architect.
all
Yes.
are motivated by
Sys-
profit.
Softech Engineers Private Limited, that is the
You
company.
get one floor more. Showing the land to be instead of 2880 to be 3880. You get one floor more. If you get one floor more, your fees increases.
But the allegation, I have understood what Lordship is trying to say, my lord.
And
But the allegation is that someone has manipulated the data inside the software.
Inside the software.
That I don't have access, my lord.
you may be a partner of that software company that you just sense this for the time being, so that software gives this result.
If that thing comes,
So therefore they are, because they are also not well equipped.
let them have their satisfaction, my lord. Whatever I have already stated.
That's right. Suppose we made it absolute today, then you are protected for all time to come. There may be materials, if they are apprehensive, why should we not wait for some time?
Let them have the satisfaction.
Yeah. Mr. Forrester Learned Counsel, additional public prosecutor submits that he may be granted some more time to get an updated case there. In as much as there may be necessity of the necessity of custodial interrogation of the petitioner if certain materials may be necessary of the custodial interrogation, full stop. In that view of the matter, the case stands adjourned and will stayed on
21st matlab, from Lotus Hill.
21st. In the meantime, interim protection granted to the petitioner shall continue.
Deeply aware.
Just have that information,
Mm.
whether they will require. If require, then they will have to satisfy us that these are the apprehensions that he may manipulate, he may do this, he may do. Since he is cooperating, that's all. Yes.
Highly aware.
Yes, Mr. Sigdar.
Here in this case, it was
Sorry, matlab, CD not to see.
were protected interim order.
When?
From
After vacation.
after vacation matlab.
You did
19.
19 interim to continue.
36.
May I pray, your lordship?
Yes.
I'm a businessman at Delhi. I purchased some tree
We'll go to your biodata later and let us see the FIR first.
at page 25.
Biodata will come later. Page
25, last
Yes.
paragraph. It was given against 3 persons, all businessmen. Last paragraph, my name is there.
CD is there.
CD is there.
But so this has been only related to non-payment of some money for purchase of tea. And a part payment of 3 lakh.
Please.
No, sir.
Yes, Shama. Goswami.
Yes. Otherwise, my lord, it's a, my lord,
Commercial
proceeding,
transaction.
proceeding.
Yes, but purchase he has not
But,
paid the
my
money.
lord, this is how sometimes, my lord, it works, my lord, in other case. That is,
It works, but this will not work.
yeah, because, my lord,
Earring worked.
yes.
That earring worked, but
Yes.
this will not work.
So when something is hanging on their head, my lord, but
That's
it
true,
may
but-
not be a my lord, proceeding in this way, my lord, but because otherwise, my lord, they are from UP, my lord. So how they will be realized, my lord, it's my lord, everything is gone, my lord.
You file money suit for it.
It's very easy to say file money.
But there is an allegation
Yes.
that you have initial deception in your mind.
my lord.
Then,
Part payment has
then
also
where,
been
where is the money suit?
Hmm.
Question, money suit they will file.
in the FIR, lordship, they have alleged that they have refused.
There
But
you have
still-
missed every all allegations are there.
Still conversation for payment is going between the parties.
That is what. my lord.
So how he
So
can
let them
refuse his
see-
only.
The learned
Any
counsel for the
progress.
petitioner prays for an adjournment. Prayer is allowed. Proceed. Now, case diary is produced. Peruse the same. The informant has specifically alleged initial deception and misappropriation. Full stop. At this stage, Mr. You are Mr.
ML Pandya.
ML Panda, learned counsel for the petitioner, submits that this is a civil dispute and part payment has already been made, and the petitioner is arranging money to pay the rest of the amount to the informant. Accordingly, he seeks for an adjournment. Prayer is allowed. List this matter.
So
List this matter when?
next week.
List this matter next night thereafter. Before
For vacation.
25th. The case diary may be returned back for updates. Interim order partial shall continue.
No, not so
Interim is
far
not
it has
there.
been given,
Okay,
but
okay. Come on. In the aforesaid, in the backdrop of aforesaid statement, this court is of the view that petitioner should be protected by an interim order.
Yeah.
Full stop. Accordingly, it is provided at Swenso. The petitioner appear before the IO within 10 days.
And submit if any.
No, you appear and on next date we'll see.
Yes.
Oh, there is no interim. I thought there was an interim.
Also,
কেমন আছে? বেল কেটে hack কর, বেল কেটে hack।
It is 430 application. FI is at page 15 lots.
Yes, you have appeared.
Yes, on 2nd of June, 1 second we have appeared lots.
my lord, on 24th of May, my lord, directed me to take instruction why again searching. Earlier again, November
statement
23 appeared.
Ah.
Now again, both of them appeared on 2nd of June, my lord.
Ah.
The statement available, my lord.
Okay. Dispose of.
Obliged, lordship.
Yes.
May I please, your lordship.
438 application, your lordship. The allegation was under section 380 and 34, lordship.
Have you gone to the police station?
Lordship.
Still nuisance is going on?
I have appeared before the IR, lordship.
Still nuisance is going on?
No, lordship.
Huh?
No.
And if we allow, will you go to create the nuisance?
No, lordship.
Sure of that? Yes.
Also, nuisance is a paramount consideration, Lordship, because Lordship 28 numbers of the villagers have lodged this complaint.
I have seen that. That's why initially we are,
Lordship.
because police has also not registered any offense under NDPS. The
Lordship.
offense registered and allegation will not require custodial interrogation. And in our criminal justice system, there is no provision for keeping them inside to stop the nuisance, except that 107 and something. This is the case of that only.
Okay, the sad thing is, Lordship, out of the 4 accused, 2 of them are minor, Lordship. They are already in child care, Lordship.
That is the difficulty, but what to do? These are all these are
And
addicts.
he was the prime one, Lordship, who went to the place of occurrence to sell the motor pump and he fled away from there, Lordship. He was the prime one, Lordship.
Yes.
His brother was arrested, Lordship.
So we'll allow you with a condition, additional condition. That petitioner will not involve himself in similar offense of similarness.
Also, let him appear for a few days to
and he will appear every week before the police officer of the before the IO of the so-and-so. আমি যে dictation. Are you aware? I said no. Appear is your appear till the IO dispenses such appearance.
39 Lordship CD not received.
Absolute plus with this additional condition.
Lordship, in this case, Lordship, remember, my lord, that the FIR is at page 9.
Remembering
The
cases
allegation,
difficult.
allegation is against the brother of the petitioners, my lord. That is accused number 1. My lord. There is not a single whisper in this petition, only because that the transaction was made in the house of a brother of a petition. This is the only allegation, my lord.
That excavator. Huh?
My lord. All allegation against Mohammad Noor Ahmed Chaudhary, my lord. And who has been already arrested, my lord, by the police. And the police asked the brothers to come and meet in their PS, my lord.
What is his role?
CD not received, Lordship.
Okay, CD not received. When?
From Hojai 21, Lordship.
21.
Short date, my lord. There is nothing against
Ask
them,
him.
Short date, my lord, Sunday.
19, Lordship.
19.
19.
62.
May please, your lordship. Lordship, Mr. Counsel came through the reason leg. So,
Huh?
Mr. Counsel came through the reason leg. So taken after some time. They are on interim, my lord. Case there is there.
What you said, you need your custodial interrogation?
They have to check no entry is there, of course, my lord.
Huh?
My lord, his father, they are father and son.
Both
are employee of the forest department. And 6,50,000 cash amount was seized from the possession of this petitioner number 2, who is father of the petitioner number 1. But petitioner number 1, there is voice recording of petitioner number 1.
That we have seen last
demanding-
occasion also they sought an adjournment due to difficulty of Mr. K. N. Chaudhary. So we said that no further adjournment shall be granted
we are-
because case there is this.
I'm not taking
No, no.
adjournment, lordship, after some time. Lordship.
Okay, after
Time being.
some.
May I please, your lordship?
There is there, no?
In compliance of earlier order, my lord, I have filed an additional affidavit, my lord, that the deposit slips, payment slips, my lord, there is an agreement. If your lordship produce the page 25 of my bail application, my lord. Page 25 and access 6, my lord. my lord, this agreement was executed on 26/2/2024. And my lord, total amount is my lord 10,40,250 rupees. 6 installment, my lord. Total, I have paid 5 installment, my lord. And as per the agreement, my lord, the payment shall be made within a period of 6 months, my lord.
Oh, that.
My lord.
My lord,
Very difficult. New techniques.
my lord,
Huh? New techniques.
he,
They are very intelligent. They know where the demand is.
he has appeared before the IO, but IO has some reservation.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after. We'll see it like an executing court. List this matter on after vacation. 17th of
And
July.
after my lord,
The case that will be returned back and produced on the Sunday.
my lord, may I pray
The interim
some
order pass
longer date, my lord?
Interim order pass shall continue. No, there cannot be more than longer than that.
My lord, out of 6, I have paid 5
We
installment.
do not know. Just let us wait after July.
My lord. Highly obliged. My lord, till then, my lord, interim order.
Date to have passed. All lost job, you have seized everything. Do you require his custody?
No, I have telephonically talked with the IO on next day, yes.
Okay.
One interesting thing, my lord.
Huh?
One interesting is there, my lord, I have annexed this test pass certificate.
No, let us not go to all this.
No,
Let us not go to all this.
all right, but QR code, my lord, I scan personally. It is saying the same mark, my lord. It is
Then
not
they may require your custodial interrogation to know what is what.
Yes, sir. Yeah,
Let us not go to
yes,
all this.
Yes, madam.
You have lost your job. You have produced a
Yes,
fake certificate.
Yes,
So many years. Investigation is almost complete. At this stage, let us not go to the merit.
My lord.
Application under suspension. Where is the case diary? Full stop. Our statements were recorded.
My lord.
Yes.
Full stop.
Statement.
No, my lord. She
So
have
not
to
recorded.
Not recorded. Yes, to
The
appear.
material so far collected by the IO in the considered opinion of this court do not warrant a custodial interrogation at this custodial interrogation of the petitioner at this stage, inasmuch as the alleged forged documents has already been seized by the police and also sent for expert opinion. Full stop. In view of the aforesaid, let in view of the present application is allowed. So and so with the following conditions, you will appear until the IO says we do not require till dispense. Dispose. Given sir.
124. Can I get 5 people?
No materials. Request, no? No? Okay, we'll come back.
Till DW8 has been examined, my lord.
When DW8 was examined?
PW8 was examined, my lord. 4/12/2023.
4/12/2023.
Page 32, my lord.
Where is that?
Page 32, PW8, my lord.
Page 32, PW8.
33.
33, my lord. Sorry. This is the type copy, my lord. Past 6, 3, 4, 5, 6, 7, 6 paragraph, my lord. The previous IO has seized mobile phone, my lord. The accused which I sent to the cyber cell department, Lakhimpur so for analysis. One constable cyber cell so analyzed the following so I found 2 photographs, 3 videos of the accused and injured condition where it is seen that the disease was assaulted with a lathi and so house of the accused. So the 41st time this has been.
Where is your cross examination?
Page number 38, 37, 38 on that.
38,
my lord.
It's in vernacular one. So this is, they have just exhibited the. So simply they have exhibited.
Order is very.
And the Lordship kindly see, there is an order also page 41 on that day, my lord. This was not played, my lord, only exhibited. These videos are not played in the court, my lord. Order sheet also says it was not played. It was simply exhibited, my lord.
330.
Now, thereafter, the 313 been recorded.
By staying silent on our petition. 330 not have a petition.
So on
Just a
313.
minute. This is 3, 4, and 5. Is not it?
3, 4, 3.
Material exhibit 3, 4, and 5.
Yes.
3 and 4 are photographs, 5 is the CD.
5 is the CD, my lord. 5 is the most important, my lord. Now thereafter straightway, my lord, the 313 started, my lord. In the 313, the learned court, by playing those video in 313, though it was simply exhibited during the evidence, it was not played. So it was, but in the 313, this has been played by the court, and question was put to us regarding the content for the first time.
Okay.
Page 61, 77, and 93, these are the questions put to us. 61, my lord.
Page 61.
61, my lord, the question number 37.
Page 61, na?
Yes, 60. Now, Lordship will find it. For the first time, it was played. Question number 37. PW8 again stated in PW9 extracted the video recording from the said Samsung belonging to your family, and after extracting the same, PW9 handed over the same to PW8, which PW8 exhibited as so and so 5. Now, 5 was played in the court while recording the statement of the accused under 313. What do you want to say? So for the first time, it was played, and we become privy to the video, my lord. So when we privy to the video, my lord, then we file a petition that it should be supplied to us, and we want to cross-examine the PW8.
But you have already cross-examined on material exhibit 3, 4, and 5.
Just simply that part, but the content, my lord.
Understand?
Content was not played.
Content may or may not be used against you in terms of non-exhibiting the content or not giving a chance to you, but whether it will be a ground to call a witness under 300 level.
Well, the content, well, the value, it was not played in the PW8. So we don't know what was the content at that time. But the while taking
That
330,
that may give you a benefit.
well, maybe, well, the court where it was gone beyond its jurisdiction, because it was not in evidence. Now taking that evidence, because 313, Lordship can see the what is the 313, Lordship can we see what the question required to put me.
Yes.
In every inquiry of trial, for the purpose of enabling the accused personally to explain the circumstances appearing in the evidence against him. So against me, madam. But these circumstances may be against me, madam. So that's why the court is taken up. But that's why I may be prejudiced if it's not been supplied and not being allowed my cross-examine. There is no question of filling a lacuna, madam, here. Because it is already there. They are using it for the first time. And it exhibited. And it was not in the evidence. Simply they have exhibited. And Lordship not simply exhibiting a document. If not do, they have to prove the content.
Yes, so that
But-
is,
but now
that is not an admissible evidence.
But the court
Why
has
should
taken-
we go
No, no.
decide all these things at this stage?
But the court has taken it, my lord. That's the problem, my lord. 313, because this is taken as an evidence against me.
No, 313, any question put, 313, the judge will have to apply its mind. 313,
Yes, sir,
taking,
so that is
taking
why-
things, so that stage has not yet come.
No, no.
Why should we
No,
apprehend?
no, they have already taken by the lordship. Why he has put that question to be, my lord, which is not in the evidence. He has showed the content for the first time, which is not in the evidence, and put the questions to us. So tomorrow, if I'm convicted on the basis of that, my lord, what will happen to me, my lord? I don't know what will happen, my lord. But the judge has apparently applied his mind on 313, which is not in evidence, which is beyond his jurisdiction. And he has put the question on those material on me. The moment, so I have the right, my lord, to those material. I have lost that opportunity for the first time. The judge has taken it. Then lordship kindly see. Then that's why I have filed this petition.
Yes.
But it will definitely may cause prejudice to me, madam, because the judge has taken it as an evidence, the content. Otherwise, there is no problem, madam. Because of that question was put to me on the basis of the evidence which is not admissible.
Do you propose to say that, forget about this case. A question put under 313, which is not a part of evidence. Okay, and that can be a basis of conviction.
Apparently, that is.
Can that be a basis of conviction?
Otherwise, no, madam,
If
because.
otherwise no,
Yes.
then because if otherwise no,
But it
then
may-
only on 313 can we apprehend that this is the only thing. We'll clarify that.
My lord, then lordship can clarify that this is not the part of the evidence, then matter is different, my lord. I have no grievance on it in that case. But the way it was put to me, I have a definitely reasonable apprehension. And there's a reasonable apprehension, my lord. This was, the CD was played for the first time in 313, and the questions were put to me on the basis of that exhibit, my lord, which is not relied during all the time. For the first time they have introduced, judge also taken so moto, which is not a part of the evidence otherwise. That's what our apprehension, my lord. That's why we are simply asking for the copy of that and the cross-examination. And there are few judgments, the similar situation has happened,
Okay, let us see the judgments.
where the Supreme Court has allowed. Here also, for the first time, it was at the stage of 313, paragraph 23.3, my lord.
20.
23.3. If the above is the vote purported on subject of examination and accused under 313, we do not see as to how the appellant, the second, can be denied to access of the document in respect of the which prayer has been made in the application dated so and dated so before the learned trial court. So 313.
Hmm.
The court has again, my lord, the lordship will find it in 23.2, the facts behind it. So basically incriminating material. Now, the moment the learned trial court has put that question, it's becoming incriminating evidence, my lord, against me. The learned trial court has definitely taken it as an incriminating evidence against me.
Okay.
So that is why, my lord, 23.3. So this is also indeed 313 state for the first time these documents were exhibited. In this case also.
Any private respondent here?
No.
Yes.
23.2 is very clear, my lord. Because it's become a now incriminating evidence, my lord. And providing those material and providing me opportunity will not cause prejudice to any, my lord, the prosecution also. Because they are relying on.
Until and unless it is a object is to delay the process.
No, my lord. It cannot be, my lord. At this stage, simply 1 or 2 dates, my lord. They are utilizing it for the first time. It is for the, because of the court has put the question. That's why we are before your lordship, my lord.
How the learned trial court dealt with these arguments?
The last annexure, lordship, can we see?
It's 110.
110.
It's 109.
9 onwards starts, my lord.
Compare 6.
The peruse the record, the 109 record, it appears that the copy of the required relevant document were already furnished to the accused at the time of commission of the case of the learned counsel court and order dated so and so is passed. Furnished to all the accused person, that is clear that the copies were furnished to the accused 2077 before the committing the case, the defense side seems to till recording the statement of the accused.
Sir,
never
does see the reason? That's why I'm asking. Sometimes we feel like it's a hellbound. Charge is to answer. This is the second time this matter is here.
Yes. But one thing, my lord, subject to let my learned friend complete, my lord, I will answer.
Let him answer. No problem.
Yes. Our anxiety is that it should not be fill up the lacuna and delay intention is not to delay the process. See, what Mr. Bora has said, that is settled, but at the same time, it is also settled that it should be raised at the earliest point of time. Even somewhere in Sasikala, this has been decided, and some other adjustments. This is one aspect. But there are two facets of this. One is furnishing, not furnishing. Suppose this is a case, if that would not have been played and ask him question, this court would not have entertained, because on M3, 4 and 5 there was cross-examination. Okay, there was cross-examination, they have not done rightly, not done, but what is the content of that videograph is not there. So far relating to certificate, it ascertains the authenticity of that document, not the content, if I am not wrong. So even they have cross-examined on the certification. Fine. But in 313, the video was played. Video is not an evidence. How do you answer to that?
Now,
otherwise, if there would have not been played in 313, then this would have been a different case.
Yes.
Then we would not have entertained this petition.
Now, question.
That part you answer.
My lord, yes. The question arises whether before cross-examining the W8, this objection, he raised any objection that you see you have not furnished these things, I cannot cross-examine.
No, he will not cross-examine, because he is to his benefit. Why should he bring an evidence which you are not relying upon?
But now he is the
now he is saying because of the 313, because you want to use it as an evidence.
No, 313 is not an evidence.
No, 313 is not
evidence.
313 is not evidence, but 313 is the statement saying that these are the evidence against you. So the judge, after 313 is not mere formality, it will have to apply its mind that these are the materials against this person. So the judge considered that to be an evidence and said that this is the incriminating evidence. Now that evidence is not part of the this is not part of your evidence. So what he says is, okay, if you are relying on this part, I will give me a copy, I will cross-examine. Just think about it. Suppose the judge would not have said that this is the material which is being said, you have done this is the video.
Yes.
So if you would have gotten the copy, he would have said that this video, this was not my face, I was not visible, this person was somebody else, you cannot this was not me. He might have said, no, this video is of in some other place. But that is not there.
He has cross-examined on that point.
No, he has cross-examined.
Page 39 below.
He has cross-examined. He said that you have not sent it. That's why I asked, where is the cross-examination?
That is what Apex Court says.
Not about the content.
No, that is why, no, my lord, that is why Apex Court says that after recording examination in chief and cross-examining the witness should not be recalled. And the category of judgment.
No, there is no quarrel on 311.
My lord, yes.
That no quarrel on 311, though power is, it's a huge power to call, but for a just decision. For a just decision.
300 is always two parts, my lord. First part is discretion. Second part is the mandatory.
So therefore, we are not on 311. Here is a circumstances, and we are not on 207 also. 207, yes, it's well settled. If you have not raised, you have cross-examined. Now at this stage, You cannot say that I was not given documents and prejudice. Where is your prejudice? You have cross-examined. You have not raised any objection, you have cross-examined. But question now relates to putting or relying on a evidence which is not part of the evidence. Now, the 313 is an application of mind of the judge, because judge, before taking a call, gives a accused a chance, saying that, see, according to me, or these are the materials, prosecution evidences against which is incriminating against you. But in his case, that part is not there. So let us examine this matter. Isn't it?
Well,
It's a case for examination.
short date maybe,
Short date.
because long pendency will affect them.
Because
but
no private respondent is there.
Private
Is-
respondent is there, respondent number 2 is there.
Is it required?
Yes. My lord,
What they
maybe,
will serve-
perhaps not,
Huh?
for proper execution of the case, for.
No, notice is not required in terms of that.
It's
Like-
between 313, it is between the court and me, my lord.
Yes, it is not required, but we'll observe that he may appear.
They may have some say
So
on.
they are
the matter.
always at.
He may
because-
need my lord double engine.
No,
I have no
I
problem
don't,
with that.
I
No, no,
don't,
no
need-
question.
no,
Double engine to run.
No, no.
But I have absolutely no.
I am on
That is
procedural
not the
law.
issue,
I am on
please.
procedural law when he has been
No,
implicated.
see,
as
what
number two.
I'm saying is,
I have not,
see,
that's why I have made a party also.
no, question is this, in terms of Deepak Nayak, yeah, he will not be a necessary party.
That maybe, but Apex Court has said, they have participated,
Apex-
right? on
Participated.
this
That's why
thing.
you'll observe
is-
that they will have a participatory.
that can be done, yes.
We are passing that order.
My lord,
In other cases also, we are saying that though they are not necessary party for implement,
my lord.
however, they will have a right. We are not.
Otherwise, I can assist your lordship in all facts and laws.
That's why we have made a party also. It's
Ah,
not that we have not made a party.
Heard
The
Miss-
requirement lordship will decide.
Heard Mr. A.M. Bora, learned counsel for the petitioner. Assisted learned senior counsel for the petitioner, assisted by Mr. D.K. Boydda and Mr. D. Das, learned additional public prosecutor. The present application is filed under section 482, assailing 480/401, read with section 207/311 of the Code of Criminal Procedure 1973, assailing an order dated 4/5/2024, passed by the learned District and Session Judge Lakhimpur, North Lakhimpur, in session case number 78 within bracket NL/2021, and arise and in a petition filed under section 207 read with 311 of the Code of Criminal Procedure by the accused therein. First, the basic by the aforesaid order, the learned judge has declined to exercise his power under section 311 CRPC to recall PW8, the investigating officer of the case, to for examination. Full stop. The basic grievance of the petitioner is that three material exhibits, three
numbers.
namely material MOP, you call it MOP?
MOP 345.
MOP 3, MOP 4, and MOP 5. Full stop. One of the material exhibit relates to a videograph
Yes.
of the alleged crime scene, alleged crime, commission of the alleged crime, videograph of committing the alleged crime
Related to.
or related to the alleged crime. Full stop. Though that document that was exhibited as exhibit videographers
MOP 5, my lord.
MOP 5. However, no copy of such videograph was furnished to the accused at the stage of giving, what you call it, copy and copies under section 207 CRPC. Full stop. PW8, who is the investigating officer, during his deposition, relied on such material and exhibited as material exhibit MOP 3, 4, and MOP 5. He was also cross-examined on this MOP. Full stop. After completion of the examination of the prosecution witnesses, when the witness was examined under section 311, accused was examined under 313 CRPC, a specific, the said videograph was played for the first time and specific questions were put to the accused. Full stop. At that stage, raising a grievance that such copy was not, though material were exhibited as Exhibit 1. However, the aforesaid content was neither proved nor furnished to the accused at the stage of section 207 CRPC, and therefore such evidence could not have been taken as material evidence against the petitioner. And in that background, the accused filed a petition to recall the petition for a copy of the said material exhibit and to cross-examine the PW8 on the said point. Full stop. In this regard, though the learned counsel for the petitioner relied on the decision of the Honorable Apex Court in VK Sasikala versus State represented by Superintendent of Police reported in 2012 9 SCC 771. However, the learned trial court below has rejected the contention of the petitioner on the ground that the petitioner had already cross-examined the PW8 and the objection has been raised at the belated stage. However, the learned trial court below has not dealt with the proposition that when a material which is not been exhibited during the trial can be put
Not taken into evidence.
not taken into evidence during the trial can be put as an incriminating material against the accused. Full stop. This matter needs further consideration. Accordingly, issue notice, let a notice be issued, returnable on. What is the next date?
My lord, 19th of June is fixed for DW.
19th of June. On when? 21st? 22nd?
Month.
24th of June 2024. Full stop. Notice to the respondent number 2 is not mandatory in view of the determination made in Deepak Nayak versus State of Arunachal Pradesh. Full stop. And therefore no notice is required to be issued to the said respondent number 2. However, it is made clear that the said respondent shall be right to participate in the present proceeding, if so desires. Full stop. Considering the arguments considering the matter in entirety till the returnable date, the further proceeding of so and so shall remain suspended. We will decide on 24th.
Order sheets of the court of magistrates court as well as trial
Okay.
court will be necessary. Scan copy of order sheets. may be expected.
Scan copy of the order sheet of the PRC case number so and so will be
And
called
session-
for by the registry.
And sessions.
You can have the copy also, otherwise this may delay the process.
Okay.
Heard. Hearing concluded, judgment reserved. Will not be possible. 68 we thought we'll dictate it.
Mal.
Reserve. Yes, hello.
Lordship will have to see the office notes, sir. Because in this case, Lordship, CBI has filed an appeal against two respondents. Lordship may kindly see office note dated 25/7/18. We are directed to take steps upon all the respondents.
What is this application?
It's an appeal against equity, Lordship.
Appeal against equital.
Yes,
Now this is leave or what?
this is leave, Lordship. Notice it is not served as on the page. Already served. If your Lordship see office note dated 25/7/18, it will reveal that notice upon respondent number 1 and 3 was not served. And service is complete in the respect of
Now,
respondent
what
number
is this statement that affidavit
is required to be filed.
filed?
Subsequently, Lordship, the Honorable Court has directed us to take dusty service
Hmm.
without mentioning that.
It's a dusty provision of dusty in case of criminal cases.
Yes, yes, but it has been, order has been passed accordingly. We took steps and Lordship, the respondent number 2 was not found, Lordship. He was out of India, Lordship, abroad. And Lordship, accordingly, we have filed a affidavit, Lordship, in this regard.
Now,
Yesterday we
a
filed-
notice is not served upon whom?
If your Lordship sees the office note
Hmm.
dated 25/7/18, Lordship may
Hmm.
kindly have a look. On respondent number 2, it was served. I don't know what subsequently this order has been passed by this Honorable Court. To serve notice upon respondent number 2.
Respondent number 2 is served.
Served.
Now 1 and 3.
1 has also been served.
Where is that?
That is on 4/5/24.
4/5/24 office note.
Office. It ought to have been, in office note, it was written as 2, respondent number 2. But if your Lordship sees the AD card, we have served it on respondent number 1.
So 2 and 3 is 2 and 3 is received.
1 and 2 has been served.
Served. What about 3?
3 is a company, Lordship.
Which company?
The managing director is the respondent number 2 is the managing director. As a floor mill.
Where is that? Show us that post title.
Lordship. Lordship may kindly see the appeal. NR roller floor mill. Respondent number 3. Page number 3 of the appeal.
Page number
3 of the appeal.
heart. Mr. Hello, learned, you are?
Special PP CBI.
Special PP CBI. The present application is filed. This is limitation.
Lordship, not limitation, Lordship.
Filed under section 5 of the Limitation Act for condonation of delay of 149 days. In where is the leave? Leave has been granted.
No. Leave has not been granted as on this one.
Where is the other IA? No, leave is not filed. This is a living condonation.
Lordship, in my
Or-
file, I have got 2 petitions.
And there is no leave is required appeal against equital.
Leave is not required.
Not required.
Not required.
Okay, so only the delay. Okay,
Also, I have, in my file, there is no application for delay.
but there is a delay. That is what criminal IA criminal 411.
Maybe Lordship, it was not there. I have got only suspension of order and the appeal only in my file.
No. Criminal LP. Criminal LP is also there.
So then I'll have to obtain the copy from the department, Lordship.
Is the department still interested?
Lordship, definitely. They
Huh?
have filed their affidavit yesterday, Lordship.
Mr. Halloy, learned counsel for the petitioner submits that since he has been appointed as the special public prosecutor CBI after filing of this cases, filing of this present appeal, he will require some time to complete his record. Full stop. Complete his record. Full stop. Reconstruct his file. Full stop. Inasmuch as he is not presently having the copy of the IA criminal number 411/2017 filed for condonation of delay. IA criminal 411 of 2017, comma criminal LP number 57 of 2017. Full stop. Accordingly, he prays for an adjournment. Prayer is allowed.
Lordship, with regard to service, There's something-
Service, we are not saying anything. You are not, service is complete in some cases. Delays are completion service will after delays completed. Condoned, we will have to issue a notice to the in LP. We cannot issue notice in all the cases together. So then again notice will go. So we are adjourning it. You collect the copy. LP is there, criminal LP is there. Yes. List after 3 weeks.
May I please, Your Lordship?
Yes.
The call for law records has been received, but in the IA, the notice is yet to be issued. State.
Notice to issue to whom?
I opposite, I state.
Yes.
Ombudsman.
LCR receipt?
Yes.
Appellate लिख दूँ. This is under which provision? Conviction under?
304 part 2.
Okay. This appeal is ready as regards record, service, and record and service. Full stop. Accordingly, list this matter for hearing in its own turn. Now, IA. The present application is filed under section
89.
under section 389 (2) of the Code of Criminal Procedure 1973 for suspension of execution of sentence and for release of the accused appellant on bail pending disposal of the connected criminal appeal filed against judgment and order dated 19/2/2024 passed by the learned session judge Borpeta in session case number 338/2015, whereby the accused appellant was convicted under section 304 part 2 and was sentenced to undergo RI for 7 years and to pay a fine of rupees 5,000 in default. Pay 5,000 and in default to undergo imprisonment for another 6 months. Full stop. Yes, 7 years. You will file an objection? No.
No, Lord.
Then argue.
After some time, my.
What after some time? Issue notice, returnable on.
The informant is not made a party, Lordship.
Is it necessary? 304 part 2. Not necessary. Let us not delay all these things. Okay, issue notice returnable on 22nd of July 2024. Mr. Sharma, Learned Additional Public Prosecutor, accepts notice on behalf of the state. No notice need be issued to the respondent number 2. In as much as he is not not necessary. Accepts notice for the state. Full stop. As he has accepted notice, no formal notice need be issued. Yes. Yes.
Statutory appeal against conviction, Lordship, that LCR not received.
LCR not received. This appeal was admitted under by this court under its order dated 20/05/2024. Full stop. The LCR has not yet been received. registry to issue reminder and list this matter. List this matter on
Is there, Lordship?
after vacation. How many years?
10 years. Lordship.
After vacation. And it will lika IA criminal. This is an application under Swencho 318 August Janaka Dilo. Same order, notice returnable on same date. You do want to file objection 10 years? In the meantime, the respondent state may file objection. Yes.
My lord, in this case, the petitioner appellant was convicted for 7 years. Now he is in jail hazard till more than 3 years or 3 months. Earlier application I was filed, but it was rejected.
Where is
now-
that? Where is the order of rejection?
That is IA.
IA?
My lord. Page 7 of my II is the order. IA number 13. IA number 1.
As per my lord, office not my service report it was awaited.
POCSO service report.
Page 7 is the earlier order as by additional report.
29/5 my lord.
Conviction is 7 years, 74 years old man. And it is alleged that she is 5 years at the time of.
What was the age of the victim?
5 years. And more particularly, they have the.
She was examined?
My lord, yes, exactly.
As?
PW1, I think.
PW?
1.
No.
No.
5 men.
Huh?
5. No man, not 5 men.
Not 5.
Not 5.
PW 7.
7.
Oh no, 7 is okay.
It's an IO.
Yes, I mean not examiner. What?
Yes. No,
You are not ready. We cannot waste time like this.
I'm sorry, my lord.
On the prayer of Mr. Ahmed, learned counsel for the petitioner, matter stands and be listed after vacation.
Yeah, please, your lordship.
Yes.
If your lordship recollects, this matter was listed yesterday. And in this matter, so far item 66 is concerned, lordship, I have been in custody from 728 days.
Just wait for a minute. We'll take up your matter today.
Lordship,
Wait for something.
lordship.
Let us finish the list.
Shall it be taken after the lunch, lordship?
Huh?
After 2, in the meantime.
Let us see how many matters are there. Yes.
I can revisit the lower court, lordship. Deeply obliged, lordship. After lunch.
Yeah, please, lordship. my lord. No, only to issue notice to respondent number 2. man.
I think you.
Decision
Yes, sir.
IA criminal, why?
In the bail application, my CD was called from my lord. The POSCO matter, my lord, no notice was issued, my lord, because inadvertently I did not point out, my lord, that day, my lord.
Okay. This is an application.
It is Thomas.
File to issue notice to the respondent number 2 in terms of the determination made in the case of Deepak Naik versus State of Assam, or State of Arunachal Pradesh. Full stop. Respondent number 2 in the connected.
Bail application, BA 1516.
Be connected bail application 1569. Full stop.
120.
Full stop. It is seen that the aforesaid bail application under section 439 CRPC is filed seeking bail in connection with Satgaon Police Station case number 81 of 2024. registered under section 376 IPC, read with section 4 of the POCSO Act 2012, full stop. And as such, a notice is required to be issued to the victim / informant, full stop. Accordingly, the present application stands allowed, full stop. Registry is to issue notice, petition issue notice to the full name allowed, full stop. It would লিখিব bail application, full stop. Let a notice be issued to the respondent number 2 in terms of the order passed today in IA criminal number 536/2024, full stop. Petitioner to take steps for issuance of notice upon respondent number 2 in terms of notification number 17 dated so and so, full stop. List this matter on 19/6/2024.
Same date.
Yes, sir.
Obliged. Correction in this order. Also with regard to service lordship, the IA cannot be disposed of without their appearance or non-appearance. So first notice has to be issued, they should appear, and thereafter there is,
No, that we understand, but before that there is a delimitation.
yes. So in limitation, they'll have to appear, they might have some objection into.
So suppose there is a notice is served. Can't we don't have power, you propose to say that we don't have power to condone the delay in their absence. Then we'll condone the delay. You are not having the copy of your petition. Then there will be question of the leave.
I got it, Lordship. I thought
Yes.
lordship, they are.
No.
Okay, may I suggest a date, lordship? And date may be
You are
fixed.
not entitled for a date. It's a 2017 matter.
Yes, lordship.
You are a standing, you are a special public prosecutor. You are not, we are without the brief.
Brief, lordship, I got just now.
Maybe we cannot be your convenience and inconvenience. See, if we pass an order that is to be corrected, signed, file has gone to my residence yesterday, somebody has taken it out, maybe one liner order, it's a huge pain, the system is to run. So it cannot be that I am without brief, so give me a date. No. It may look simple, no. And this is a 2017
No,
matter.
I got the brief.
For you, it may look simple, but system runs very tough to run this system. It's not that everybody, somebody will have to take out file, send a vehicle to each judge's residence. The judge will read and next day will say, I want to have an answer. Matter adjourned one line, again gone to the my office, I will correct it, sign it. Again, somebody will take to the section. Again, next day, it will go to our residence of a judge. It's not that easy. Yes, next case. None appears for the parties on call. Release this matter after 3 weeks. Interim order passed as self-opinion. Yes, rest. Next second half we'll try.
It was called for, my lord.
Okay.
Obliged.
You are for respondent.
I am for respondent,
You
madam.
are for petition.
To withdraw.
Yes, Bhattakur.
I have handed over.
There is no formal order.
Formal cognizance. So then how without cognizance search can be done? So it will go to a cognizance, nothing.
That will,
Should, huh?
that will go to, that's from that stage only things has to be started.
Lords, obliged.
Obliged.
এটা কোনটো এটা না রাখ এটা সেভ হয়েছে না এটা কি হয়েছে এটা এখন কোনটো Yes, sir. Yes, what is this?
My lord, I'm in item number 66.
Yes.
Lordship,
Oh, that case, bail.
bail, my lord. Lordship indicated that after last night.
Wait for son. Mr. Bhattacharya's case.
Yes, yes.
Okay,
After
okay.
the-
Wait for son.
22, admission method.
Meet the lordship.
Yes.
Petitioner filed a IA for recall the warrant and for payment. And after petitioner appear before the learned trial court and make payment 37,000 rupees. And so, my lord, now I am going to withdraw the IA. IA 189.
Yes, yes.
Petitioner appear before the learned trial court and make payment 37,000 rupees. Next date for payment on coming 15,
What is the amount of areas?
near about 1 lakhs,
Now, how much you have paid?
37,000 rupees. 37,000.
Yes, what is it? It's
Sir,
better that matter should be kept pending.
This is fixed on 15 June, Lordship.
15 June. Okay.
Now,
List after 15 Lordship. For instruction. I Lordship 189, no?
189.
In fact, was Lordship.
What is this IA?
IA
Recall for
recall for warrant. DW.
Okay, I'm not saying anything. The respondent number 2 is duly represented by the council.
This is not time because coming 15 days, I am unable to pay. Just for 1 month or 2 months. That's for 1 month or 2 months.
After vacation.
No case is made out. We can dismiss it, but we are not dismissing it today.
Just 2 months. I have already paid 37,000.
Learned counsel for the petitioner submits that matter may be adjourned for a month in as much as he has already paid an installment of the area of maintenance and is trying to clear the remaining areas. Prayer is allowed. List this matter on after vacation. Give it 29th of July 2024.
May it pleases your lordship.
Yes.
Lordship, this is an appeal under section 374 of CRPC, lordship. It is an appeal against the judgment dated
What is the punishment?
lordship 10 years.
Admit, call for the record, please notice.
10
As Mr. Das learned, if you accept notice, no formal notice need be issued. That's all?
For lordship.
We have already called for them.
My lordship.
24, 25.
Yes.
In morning, I mentioned this matter for adjournment for today or not. Respondent side was not informed, therefore matter was called.
Charge sheet has been filed.
Substitute case.
Okay. You are getting benefit of exhaustion today. On the prayer of the learned counsel for the petitioners, list this matter after vacation and on, give a date. Scan copies received?
Scan copy received.
Huh?
Received.
23rd of July 2024. Interim order pass earlier shall continue till then. Both the cases, huh? Yes.
So na pasok na po na timing.
No time being today.
Lordship, it is for.
There is no time being on Fridays. That is,
For crossing of the proceeding, Lordship.
crossing off.
FIR, Lordship.
Scan copy has come.
LCR is received, you know.
Where is the FIR?
Lordship, FIR is, Lordship.
Yes.
FIR is 11, Lordship.
Behind it too.
No, is the Lordship.
Offense.
Informant, the petition.
What is this? I'm not getting anything.
Lordship.
What is that? Keep the truck that is engine to his home.
Yes, Lordship. This is the FIR, Lordship. It is the owner of the truck lost the FIR, Lordship.
You are a driver or what?
Lordship,
What
now,
happened?
actually what happened in this case,
Huh?
the driver, he
Huh.
took the truck to Ahmedabad. He
Huh.
was on his way to Ahmedabad, but without informing the owner, he stopped at his native place and put the trailer in by the side of the road and took the engine to his home. Then on the next morning when he came back, he did not found the trailer there. And subsequently, trailer was found in Bahatasariali and its tires were removed. So thereafter, this FIR was lodged in between. And now the owner, he came to know that the driver was not involved in the theft. So he has filed. And interestingly, the driver is still driving the same truck.
No, that we understand. But now quashment under what ground?
On the ground of there is a compromise.
Where is the compromise?
Lordship,
What is the other side respondent?
Order the 10-5 may be seen.
Lordship, both,
10-5.
this is a joint petition.
Joint
but
petition.
Yes, Lordship, informant and the accused.
Lakshmi Narayan disposed of.
Macho.
Where is that agreement?
Lordship, that affidavit is there. That affidavit, another. No, actually, they have filed a petition because this is a joint
Jointly.
petition.
Jointly.
Joint.
Where are your statements? Which paragraph?
Lordship. Petitioner, it is in
Paragraph 5. Paragraph 6, paragraph 7. Unifacts, huh? Then
Lordship, paragraph 13. That the petitioner's begs to state that the informant, that is the petitioner number 2, later came to know that the accused person was not involved in the aforesaid crime,
13.
and were therefore.
Okay. Disposed. But not before next Tuesday. Yes, Mr. Sir.
The husband of the petitioner was living in, my lord, relationship with another lady. My lord, he was in Calcutta. He filed a divorce as well as guardianship case in Kolkata Appellate Court, my lord. Thereafter, he shifted to Banjara Hill, Hyderabad, my lord. He's a very rich person. I am a very poor, my lord, and I am residing at Dibrugarh now. I filed a petition under 125 CRPC as well as
Very
DBF.
poor.
My lord,
Mr. Sahewala is arguing and he is very poor. In a lighter sense. In a lighter sense.
now what happened? I have to file an application before the Supreme Court for transfer of the divorce case, my lord. And there, my lord, some mediation was taken. Some agreement was entered into. In fact, my lord, there was some objection again, my lord, it came to the court and that is pending now. Now, in the meantime, what happened? On 12/5/2003, husband of the petitioner came to Dibrugarh and, my lord, influenced the child welfare committee, my lord, there. And they went to the school, got some statement of the girl, and thereafter lodged an Ejahar, my lord. If you also see, Ejahar is page 110. 112, my lord, your lordship may see. Peculiar, my lord, the order has been passed.
Hundred
112, my lord. It starts at 110. With due respect, we would like to inform you that we have received an information regarding a child abuse case
her own child, my lord, petitioners, Aditi Khemka, daughter of Arvind Khemka and Meghna Khemka, so and so, Zen Mandit, Dibrugarh, by her mother. Accordingly, we, a team of CWC members, visited the Flower Higher Secondary School, Dibrugarh, where the girl is studying in class 4.
That 112, isn't it?
112.
Scan copies has come?
Wait, listen, so I
Yes.
for the respondent number 2, and I was instructed to appear, and I have not received the copy, and we will file the wakalat number.
My lord, may I see, my lord?
Yes, you appear, but I do not think this,
My lord,
this
same day, my lord.
for the time being, just a minute, just a minute. Here. What is the age of the victim?
Class 5, my lord. Class 4. Class 4.
Who is Pushpa Agarwala? Versus Motiram or something like that. The Honorable Apex Court says that the defense of exception that it was not defamed in the eyes and esteems will come at the stage of trial, not at the stage of cognizance. What do you answer?
If, my lord, that is in the initial stage, this has come up.
Initial.
Complaint case.
Complaint
200
case, that
was
is defamation.
200
That says exception 4 is a matter of trial, not at the stage of inquiry under 200 or at the taking of the, on the basis of the complaint.
So cognizance was taken, my lord.
That's why your argument is not having substance. Sorry to say. And on your behalf, we are arguing, we are asking question. So those arguments, Article 21, I have a right of reputation, these are all there. We are aware of that. But you have filed a case under 499 alleging defamation. Now, what is the meaning of defamation? Defamation, as per your understanding, will not do in a courts of law. You may think that you have defamed. Defamation is not by you. Defamation is the eyes and esteems of the other.
I beg to state that.
Take your seat. Take your seat. And what do you say about that?
Before I proceed into that page.
Because I could understand your argument. Nothing but
So there
emotion,
is-
nothing but emotional argument.
No, one
And
thing-
we cannot run by on
one thing-
emotions.
one
We are
thing-
on legal
one thing I
points.
have to
Yes.
My lord, there are 4 witnesses that have been examined.
Yes, that is the
including-
inquiry, 200.
Yes, inquiry 200 and 202.
Uh,
And my lord, cognizance was taken on the basis of those statements. If
so
there would have
that is
been
Supreme Court in that case said this is a matter of trial.
material, if material is there, my lord. In this case, page 29, that is his witness, my lord. Come to page number 29 for a moment. What he has to say, my lord. He is negating, he is in fact, though he has examined as court
Okay,
witness.
you are also not prepared. Let me read the paragraph. Before concluding the discussion, it is to be stated that the trial magistrate has given instructions. The reason is that forget about this facts. In our opinion, the question of application of exception to the section 499 IPC does not arise at this stage. Rejection of complaint by magistrate on the second ground mentioned above cannot be sustained. It has to be unnecessary for the High Court censure. It is needless to say that the question of applicability of exception to the section 499 IPC as well as other defenses that may be available to the appellant will have to be gone into during the trial of the complaint.
But my lord, that this particular judgment with due respect, my lord.
Have you ever read this judgment?
No, my lord.
Don't argue if you have not read this judgment.
No, the paragraph that my lord.
Paragraph 29.
Yes, my lord. On that count, my lord, I am.
Here is a count. Let me tell you. There also these were considered, and that exception was considered. That it is to be defined as an exception to the 499.
My argument is, my lord, a little bit different, my lord.
Yes, what is your argument?
My argument is solely on the basis, my lord, that whether the materials that is before the learned trial court placed by the complainant side, my lord, whether it makes out
He has said,
prima
I have been
facie.
defamed. These are the statement made, I have been defamed.
Prima
Whether
facie-
he is defamed by in the eyes and esteems of others, which is given in the exception 4.
My lord.
Let us read 499. Yes, IPC.
$499, my lord. And my lord,
Yes.
may I place a judgment of our honorable court, my lord, division bench, my lord, which is similar to the facts and circumstances of my case only, my lord, that is printed and it is okay.
Yes.
My lord, before my lordship go into this particular judgment, my lord, only one, because two statement my learned friend has already placed before this honorable court. But with regard to the third statement that my lordship for a moment may kindly come to page 29, my lord, of the my petition, my lord. Here, my lord, para 20, second last page, my lord, para 20, may I read, my lord?
Mr. Das,
My lord.
this is a case where after full trial, a determination was made. This was a judgment. Their court came to a conclusion that these were not available. We are at the stage of 482.
482, my lord. My only.
So, do you expect us to determine this? Any word spoken or written would be defamatory if it is exposes to the plaintiff to hatred. He alleges. Now, your exception is that he must be defamed in the eyes and esteems of other. He will say will not do that. He has defamed.
Some material has to be there.
Has to
my
be
lord.
produced.
Otherwise, my
So
lord.
therefore, the Supreme Court in quashing stage said that this is not the stage. He may bring tomorrow a witness and say that yes, his eyes and esteems. He says, I have been defamed. Enough. Now, whether his actually defamation would be at the stage of trial as per Supreme Court. That's why I'm asking this judgment. What is your explanation?
My lordship may kindly see the statements, the witnesses which he brought to the court and the, my lord, deposition. Those witnesses, because my lord complaint petition, my lordship knows there are no previous statements like 161 in police case, my lord, recorded by police.
I understand.
In the complaint cases, my lord.
That's why the statements are recorded. Otherwise, on the basis of complaint,
Yes,
cognizance could have been taken.
corroboration and
Because
contradiction.
this is the material initially court to have a satisfaction that yes.
And at the very inception, if he's, my lord, there is absolutely no material, whether putting me into trial, my lord, whether it will be an abuse of the process of the court, my lord, in the putting me in the trial without any material, my lord. Entire process for, my lord, many years I have to face, my lord, trial in the court below, my lord. That is why I have come before this honorable court with a prayer, my lord. And para 20, my lord, there his statement, my lord, page 29, his witness, my lord. For a moment, kindly come to page 29.
Yes.
I said that it is not possible. Second line, my lord. I said that it is not possible as the complainant is having his own children. Later on, accused made allegation that the complainant has taken 47 lakh. Said his statement is also false one. In as much as the complainant having said amount of money, he would have returned my money, which he had taken from me, and his business would have run smoothly by now. But I know that the business of the complainant is going down and he is not in a position to return back the money taken from others. So as per his allegation, what imputations I have put against him, that he had taken 47 lakhs from me. But that is, my lord, if I would have had said that he had taken 47 lakhs from me and he is not returning the said money, my lord, then yes, that can be, my lord, understood to be a defamation, my lord. But that not I have stated, my lord. Nowhere it is there on record, my lord. In fact, this particular witness has said he is not returning the money of others.
Yes.
And my lord, he eyes an estimation, my lord, his wife herself has come to the court for deposing. If she would have, my lord, all the witnesses, my lord, all the witnesses, no one has said, my lord, and supported his case that his reputation has been hampered in the eyes and estimation of their eyes. That is why I have placed this judgment of the honorable division bench of
What is the paragraph of the
paragraph 20, my lord, second last.
Please read it.
PW1, the plaintiff in his deposition has stated about lodging of complaint dated 89/97. He has also stated that he has been looked down by public as a corrupt officer, though he is not a corrupt officer. Such version of the plaintiff, however, has not been supported by other witnesses examined. Then PW2, my lord.
So you want to deal with me that evidence at this 482 stage?
No, my lord.
Initial
my-
deposition.
No, yes, my lord. My
Huh?
prayer is, my lord, my prayer at this stage, my lord, in absence of the materials which are prima facie required for taking cognizance under section.
So therefore, I have put a specific question to you.
My lordship.
That's why I ask you to read section 499.
My lord.
Whoever by words either spoken or intended to be read or by signs or by visible representations makes or publishes any imputation concerning a person intending to harm or knowing or having reason to believe that so and so on and so forth. A person thinks that this is a defamation. Okay. Now it says there are some explanation. Okay.
What I am saying, my lord, is that this is not defamation. If I would have had said, my lord, I already submitted, my lord, 47 lakhs he has taken from me, that he is alleges that I am saying, my lord. If I said, my lord, that yes, he has taken money, he is not returning money now. And for that effect, my lord,
Okay. Let him hear us. You take your seat.
My lord.
Yes.
Apart from that, all the issues, ifs and buts, they have never explained in their petition that their cases comes under 10th exception of 499 IPC of 1860. Secondly, all the witnesses, those who have appeared, they are attached to me. They came because they attached to me.
They have not been defamed.
No,
But
my
you have not been
my
defamed.
wife told here,
Huh.
his fame and name
No,
was.
your wife told you that.
So it has hurted her sentiment. That's why she told.
No, she that might have hurt her sentiment, hurting her sentiment, and
No, it is clearly mentioned there.
no, she said that French and all are. I was surprised.
What
and
are
French are all.
what are the questions made by the learned SDGM one? Accordingly, she has replied. So whatever she asked. So if I do not get the chance to defend myself in the trial court, then how it will prove that I am innocent or she is innocent?
Okay, then next.
So my innocence should be established. My reputation. 10 years I'm fighting this case.
No, forget about 10 years
just-
fighting.
No,
You
it
may
is.
fight 100
it
years.
is
That
the-
is not the issue. Issue is whether a case is made out.
So
Argue on that.
it has directly hurted the sentiment, and even when she has told that I had agreed to marry her, that's so. It's
Okay, and
complicated.
next point.
Next point is there she has not appeared before the court anywhere. If she has guts, she was why she has given petition of mediation. Why she has
That we
so,
cannot answer.
accordingly, she is in because if I've taken 47 lakhs from her, no one will give 1 lakh without any written documents. If I've taken, she may have some issues That's
No,
why she has given.
These are
Uh,
whether you
so
have take whether
there is
whether
no,
you have taken money or not, is a truth or not. These are not the issue.
not the issue, but
is
she has
who-
told,
Huh.
she has told. It was recorded in the statement. She has told this thing. She don't have the proof or not, I don't know, but she's house
Okay.
was under CCTV surveillance since 2011. So if someone takes something, it will be recorded in that too. She will utilize it basically because it was totally.
Okay, next.
So in that case, I was defamed, and my humble prayer is that to the honorable court. The court should act according to the within the
Hard.
frame of law, without fear or favor, nepotism, favoritism, prejudice, and vindictiveness.
Hard.
Resistance.
Mr. Trust, learned counsel for the petitioner, and you are Mr.
Ratima Swami.
Raktima Goswami, the respondent number two in person. Two or one?
Two.
I'm respondent number two in person. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing of complaint petition, quashing of complaint petition being complaint case number 1046/2014 filed by the respondent number two alleging commission of offense under section 499 IPC. The further challenge is an order dated 23/7/2015 passed by the learned subdivisional judicial magistrate 1 Kamrup Metro at Guwahati, whereby cognizance of offense under section 500 was taken. Full stop. The respondent number two filed the complaint comma statement filed a complaint. Full stop. The allegation made in the complaint can be summarized as follows. The petitioner accused in the complaint case has been spreading a rumor to defend the complainant among his friend circle that the complainant is in love with the accused person and that he has given a marriage proposal to the accused. And the further allegation is that the complainant has also been defamed by the complainant in as much as for the reason that she also had made statements that the complainant had taken rupees 47 lakhs from her. Full stop. According to the statement made in the complaint petition, this has affected the normal life of the complainant as the fame and good reputation, he used to earn from his friend circles, relatives, neighbors, and society as large is being hampered to great extent. And he is now being looked down upon with disrespect in the society. This is according to the statement made in the complaint, such facts alleged by the accused are concocted and false allegation which has led to miserable which has made the complainant's life miserable in his economic front, since the friend circle has now stopped working with him and his friends in the business circle started to treat the complainant with suspicion. It is the further case that the business fraternity as a whole stopped involving in new projects with the complainant. According to him, the defamatory words were so detrimental to the reputation of the complainant that now his business is being affected. Thus, the accused person had hampered the reputation of the complainant by her defamatory statements. The full stop. On the aforesaid application being the full stop, the complainant was examined by the learned magistrate under section 200 CRPC before issuing process. The complainant in his statement recorded under section 200 stated that the complainant the accused informed the complainant that her husband used to torture her physically and mentally, and she needs the help of the complainant. The said accused also requested the informant to give some false evidence against her husband and also stated that she was having an affair with another person. Full stop. When the accused refused to accede to her request and started ignoring her, the accused started to make some statements before his friend circle and his acquaintances that the complainant that the accused had given marriage proposal that the accused has that the complainant has given marriage proposal to the accused, not the accused proposed the complainant proposed given a proposal to marry the accused and also had taken 47 lakhs rupees from her. He, in his deposition, stated that the accused has stated many rumors against him. And therefore, the estimation of the complainant has been lowered before the family members and society. As many as how many witnesses? Huh?
3 witnesses.
3 witnesses were examined.
Court witnesses.
Court witnesses examined. Full stop. One of them is the wife of the complainant. Full stop. The wife of the complainant deposed that the accused started to make statements before her music society against the husband of the witness, that the husband the complainant had taken a sum of rupees 40 lakhs from her and also made Moro's marriage proposal to her. After hearing the same, she was surprised. It was further stated by the said witness that for the statement, for the reason of the statement made by the accused, business of her husband along with his name and fame has been affected. And for the aforesaid statement of the accused, his business partners has refused to involve the business partners of her husband had refused to involve him in new projects. Another witness is this is auto driver.
My lordship.
Sabyasachi Bose.
My lordship, page
Hmm.
24.
Huh?
Page 24.
Who is he?
Sabyasachi. He's, my lord, it seems he is not stated, but it seems knows the complainant.
According to him, the accused informed him that the accused had initiated a divorce proceeding against her husband. No. And after filing divorce, the accused gave her a marriage proposal. It was also, according to the said witness, it was also stated by the accused to him that the accused, as the accused was married and was having children, he refused such marriage proposal. She refused such marriage proposal. It was further stated by the said accused that one day the accused told him that the complainant has taken rupees 40 lakh from her. He further stated that due to such statement, the business of the complainant got hampered. Who are the others?
Page 28, my lord. He is the tenant of the complainant. Page 28 and auto driver.
Another witness, namely Aziz Ali, was examined, who is a tenant in the house of the complainant. And he is an auto driver.
Auto driver.
He's an auto driver, auto rickshaw driver. He stated that the accused, while traveling in his auto, told him that complainant took a sum of rupees 47 lakhs from her and also gave her a marriage proposal. He further deposed that he did not believe her and remained silent. However, many persons inquired him whether complainant had married the accused or not. He further deposed that the allegation of taking 47 lakhs by the accused from accused from the complainant is also not correct, as the complainant is having not that much that this is I am not getting anything.
It does not, my lord, he said it is.
No,
not
that we
possible.
understand, but she said he demanded money. She has paid money, 47 lakhs.
Lordship.
Okay.
But not said that he is not returning. This witness said, my lord, he does not have such amount of money.
So, for the reason that had if he had such amount of money paid by the complainant, paid by the accused, the complainant would have returned the money due to the said witness. This is his case.
And after, my lord, but I
And
know that
also, he would have in position to return back the money taken from others. He also deposed that after knowing that the accused complainant had taken money from the accused, the business partners of the complainant refused to give him money. Stop. The learned counsel for the petitioner in the aforesaid backdrop submits that no cases under section 500 is made out inasmuch as allegation relates to a dispute between the complainant and accused and financial transaction and nowhere relates to any offense of defamation. Full stop. According to him, none of the witnesses examined has stated that for the alleged statement of the complainant, the
no witness has said that my statement is false. my lord.
Statement none of the witnesses stated that the allegation made by the accused has harmed the reputation of the accused in their eyes and estimates. Rather, they have stated that nobody has believed such statement. And therefore, according to him, in terms of explanation 4 to the section 499, no case is made out either from reading of the complaint as well as from the deposition made by the witnesses. Full stop. According to him, if the entire facts narrated in the complaint as well as in the deposition are taken in its face value, then also no cases under section 499 is made out. Par contra, the learned par contra, the respondent number 2 in person argues that his reputation in the eyes and he is having to maintain a good reputation, and such reputation has been infringed by the action of the petitioner accused, petitioner/accused, and there are specific averments in the petition that he has been defamed by the action of the accused person, and therefore this is not a fit case where this court should exercise its extraordinary power under section 482. Full stop. The respondent number 2 further contends that this court should exercise its power of revision in rarest of the rare cases and in exceptional circumstances. Full stop. Exceptional circumstances. According to him, in the case in hand, a bare reading of the complaint as well as the statement of the witnesses recorded clearly discloses that there is clearly discloses that offense under section 499 is made out. 499 is made out. The respondent number 2 further contends that the whether the accused not accused, whether the complainant is actually defamed or not is to be proved at the time of during the trial, and during trial he will be able to examine other further witnesses on the basis of which a determination can be made whether the complainant is defamed or not. Therefore, at this initial stage of the prosecution, this court should not exercise its extraordinary power to quash the entire proceeding. He further contends that the learned magistrate has rightly taken cognizance of the offences after considering and examining the statement of the witnesses. Accordingly, he submits that this petition is liable, devoid of any merit, and therefore liable to be dismissed. That's all. Okay. In this regard, he relies on the decision of the Honorable Apex Court reported in so-and-so versus so-and-so 2016 4 SCC 243. Okay. In terms of section 49, an offense under section 499 is committed when committed when a reputation of a person is harmed by either by words, by signs, or by visible representations. Etc. Etc. Subject to the aforesaid provision further clarifies, explains that an imputation of a person can be said to be harmed when such reputation is harmed directly or indirectly in the estimation of others, and such imputation must also directly or indirectly lower the morals or intellectual character of that person who alleges to be defamed. Full stop. It is true that every man has the right to have his reputation preserved. And it is also true that right of reputation is acknowledged as an inherent personal right of every person. However, for taking a cognizance of the offense under section 499, the complainant is to prima facie show that defamatory statement has been made or published and it tends to lower the estimation of the right-thinking members of the society in general. Full stop. It is also equally well settled that to find out whether the statement is defamatory statement or not, to prima facie come out whether the prima facie come out whether the statement is a defamatory statement or not, the court is to take note of the statement made, entire statement made, and read the take note of the entire statement made in the complaint. Full stop. While taking cognizance of an offense, comma, the issuance of process and the procedure for taking cognizance is not a mere formality. The magistrate is to apply its own mind to the complaint and determine whether the statement is prima facie, this statement made are prima facie defamatory, comma, before issuing summons to the accused. Full stop. It is also equally well settled that that in criminal jurisprudence, if the allegations contained in the complaint do not constitute the offense complained of, comma, then the accused should not be made to undergo the ordeal of a trial. This court can place reliance in this regard of the decision of the Honorable Apex Court in the case of Manoj Kumar Tiwari versus Swenso reported in Swenso. Okay. I'll give you the citation later on. Hmm. In the case of National Bank of Oman versus Barakara Abdul Aziz, the Honorable Apex Court laid down a principle that it is the duty of the magistrate receiving a complaint and then it is having also an obligation to find out if there is any matter which calls for investigation by a criminal court. The such scope of inquiry under section 202 CRPC is limited to the ascertainment of truth or falsehood of the allegations made in the complaint. For the it is for the limited purpose to find out whether a prima facie case for issuance of process has been made out. The Honorable Apex Court, in the case of IFCO Marigas Swenso versus Nirmal Kishore Bharatia, after dealing with the earlier decisions of the Honorable Apex Court involving the offences under section 499, has laid down certain principles. The Honorable Apex Court in the aforesaid case held that a magistrate taking cognizance of an offence proceeds under section 200 based on a prima facie satisfaction that a criminal offence is made out, comma, he is required to satisfy himself by looking into the allegations levelled in the complaint, the statements made by the complainant in support of the complaint, the documentary evidence in support of the allegations, if any, produced by him, as well as the statements of any witnesses the complainant may choose to produce to stand by allegations in the complaint. It is further held that a magistrate decides to pass an order summoning the accused, comma, examination of nature, comma, is not intended for forming an opinion as to whether the materials are sufficient for a conviction, comma, instead, comma, he is required to form an opinion whether the materials are sufficient for proceeding as the title of relief proceeding, full stop. Full stop. It is further held that since the accused does not enter the arena at that stage, comma, the question of accused raising a defense to thwart the issuance of process does not arise. It was also held that the fact that accused is not before the magistrate shall not mean that the magistrate need not apply its judicial mind. Full stop. It was also laid down that a magistrate can even look into at that stage to the exceptions to prevent a frivolous complaint from triggering an unnecessary trial. In the aforesaid contracts, let this court deal with the present case. A reading of the complaint as a whole and the statement made, statement examined, statement of the witnesses examined, produced by the complainant in support of his contention and examined, discloses an allegation that the complainant has made statements before different persons that the accused had given a marriage proposal to the complainant. And according to the complainant, such statement made by the accused has defamed his reputation in the society, in the eyes and esteems of the society, more particularly amongst his friend circles and known persons. There is no doubt that a specific statement has been made in this regard. Full stop. Statement. The other aspect of the matter is that the accused has made a statement before the friends and other persons of the society that the accused had taken an amount of rupees, complainant has taken an amount of rupees 47 lakhs from the accused. And such statement has harmed the business reputation of the accused, inasmuch as his business partner had lost faith upon him. In the considered opinion of this court, the second statement and contention in any way will not come within the definition of defamation in terms of section 499 IPC. Now, coming to the other part, to prove, to prima facie show, not prove, to prima facie show that the name and fame of the petitioner, complainant, has been defamed in the eyes and esteems of his fellow men. He had examined 3 witnesses. None of the witnesses has disclosed that they believe that the statement made by the accused, as discussed herein above, has had lowered their estimation of the complainant. Full stop. Except the statement of Srimati Sonali Swami, the wife of the husband, who also stated that for the statement made by the accused, business of her husband along with his name and fame has been affected. However, she has not deposed that his reputation has been lowered or lowered in her eyes and estimates. Therefore, prima facie from the aforesaid materials, no case of defamation is made out. Therefore, this court is of the view that allowing this allowing the trial will be an abuse of the process of this court, and accordingly, the present petition stands allowed. I'll tell you, forget about the judge and individual. A defamation case is where your witness says against you. Your witness will have to say that, yes, he was a very good man in my eyes and esteem. Now, after Mr. Das has said this to me, I don't believe this man. He is a gone man. My reputation is finished. Your witnesses say, no, these are not correct. These are false things. So you have not been defamed. That is the difficulty. Deeply. There is a fine line.
But my wife told
Your wife told that his reputation will be defamed in the other side. She cannot depose on your behalf. Understand? This is the main problem. If they would have said, yes, I like this man. He was a very good person. He has a first of thing, there must be a statement. We'll just elaborate this. There must be a statement that they had a high esteem about you. First. Second part is that because of this so and so stated before me, so because of this statement, now I don't believe his esteem has gone. That's all. Only that much is required, nothing more. Nobody has said that they had a high esteem about you. That we have not gone into. We say that since they have come, but nobody whispered that in their eyes your esteem is lowered. That much. But your anxiety is over.
Now it will start.
It will
start. I'm passing through a darkest part of my life. It will
that happens.
It will go darker.
No, we are bound by the legal parameters. Yes. Just give me quick points. What is your ground for acquittal?
Just take 1 minute time for your lordship.
Yes.
Because I can understand the lordship might be exhausted by now.
No, today, in fact,
Because
I was not
quite-
feeling well. I thought that I will not take up other methods, but still I thought that no, he is inside jail and this man has written a letter to the High Court saying that my case is not being taken up and this is a scar on us. So I thought, no, I'll have to take up this matter. And he's personally present. What happens is that different. At least he's been given a hearing.
Yes, hearing.
That's all.
Now, lordship, let me come to my point.
Yes.
Here, my points are very simple. Here, when lordship heard me, lordship was of the opinion that if I'm using some words, lordship will kindly excuse me, lordship.
Yes.
That if there is some lacuna in the prosecution case, now the lacuna in the prosecution case has been defined by many judgments, which says that the lacuna is an inherent lacuna which cannot be cured. Now, here, lordship will say, I am heavily relying upon PW2 lordship, who has become hostile, being my wife lordship. I can understand here also there is another judgment which prosecution may rely that wife being a highly interested witness may become hostile. Now I am coming to 3, 4 and 5. These are the independent witness of seizure. And this independent witness of seizure lordship, they have deposed that they have signed in the seizure list. They have signed in the seizure list lordship inside the police station.
Who are these witnesses?
These are independent witnesses, 3, 4 and 5. Lordship will kindly kindly take a cursory look only, starting from page number
What?
65, my depositions.
You have annexed it also.
Yes, 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 I have annexed it.
In the IA?
In the IA also, Lordship. In the IA. It starts
Page-
from page
page?
number 65. Lordship may kindly take from page number 70. PW2 who will become hostile. Then PW3, Lordship will kindly see these are all independent witnesses, and they have said that they
Just a
have
minute, please.
page 72 onward, Lordship.
Page
72, if your Lordship may kindly take up for a moment of time. Page 72.
72.
I'm just reading the chief, Lordship will kindly come to sentence number 3. I do not know the other accused. About 6 to 7 months ago, one day police came and arrested Sanjit Goyari from his house. On next day, I went to Majbat police station to see the accused. At that time, police obtained my signature on some papers. Now, this is the seizure list. This is same evidence, the Lordship may kindly see, same evidence is coming from PW4.
How many witnesses are there for seizure witness?
Three witnesses.
Who are they?
3, 4, and 5.
This is 3.
Then 4 also, 74, page number 74, Lordship. Same statement.
Then,
Next day, then Lordship may kindly have a look to page number 76, Lordship. Same statement. On next day, I went to Majbat police station to see the accused Sanjit Goyari. At that time, police obtained my signature.
And
on
what
some
is the
paper.
other? These are the seizure witnesses.
Seizure witness. Others are police, and informant is a policeman. Seizure has not been proved.
How many days you are behind?
Lordship, I am behind as on today, Lordship, 728 days. And
What
I
is
have
the
given back to a
conviction?
child, Lordship.
Conviction?
10 years, Lordship.
10 years.
I have given back to a child, Lordship, and
Now, my lord, if
See,
your lordship
foundation, you have been failed to lay the
that
foundation.
is, my lord, yes, that part I will submit when it come up for my lord, appeal. My today, my lord, the lordship, there is a fine distinction, my lord, whether today my lordship is taking up only the IA, my lord. IA, my lord. In IA, my lord, there other aspects has to be considered before going to the my lord merits, my
Yes.
so my lord, if the IA your lordship wants to dispose, my lord,
Hmm.
then there are certain things, my lord.
Yes.
In NDPS, my lord,
Hmm.
it is not like other normal criminal appeal, my lord, where they're going to
So
the
as per my limited knowledge, what I could learn
yes, yes,
is that in a NDPS case, the burden is reversed.
burden is reversed.
Presumption is against him.
Them, yes,
But at the same time, when presumption is against him, the foundation is to be laid by the prosecution. That
Yes.
this is the foundational fact.
Yes.
Once this is established,
yes,
then
Then
burden shifts to
yes,
elected.
yes, yes, that is true.
So just because
Yes,
I
yes.
will have to shorten this, because
because-
what is in my mind, if I express, you can respond to
Yes.
it. So therefore, when a serious doubt as regard this basic foundation of recovery from the conscious position is doubted, then what will happen?
My lord, yes, my lord, that has to be addressed, and my lord, I will address it in when the whole appeal is taken up for hearing, my lord. Now, my lord, parameters is that, my lord, the normal appeal, there are no, this is a, my lord, appeal under, my lord, NDPS and a special act, my lord.
Mm.
In special act, my lord, there are, my lord, certain, my lord, principles that has been laid down.
Yes.
The first is, my lord, this, my lord, section 37, my lord.
Section 37. Section 37 is all throughout.
Number 2 is that, my lord,
Hmm.
the, my lord, here, my lord, bail before at the stage of trial.
And
is a
after
prin-
conviction is to
is a
differ, because
principle.
already he has been convicted.
Yes, and it is now conflict. So my equal lordship's section 37, my lord,
Hmm.
what it says.
NDPS.
So these are the, my lord, just preliminary issues where your lordships might be dealing with
NDPS.
while deciding the IA, my lord.
Because hearing today is not possible.
Not possible, my. That is where
There is a preliminary objections regarding the granting of
Bail.
my lord. That is what.
Okay, let us see page 37.
Yes.
This simple case is that
Yes.
foundation is not laid down. It's a
Yes.
clear case of acquittal. So therefore,
He
bail
might
should be
be,
granted.
that I don't deny, my lord. He
Adding,
might,
adding just one line,
Ah.
the recovery made from me does not come under commercial quantity.
Okay.
So 37 will not be applicable against me.
no,
Although I've been convicted under 20 B2C, Lordship, recovery made is 1.1018 gram. So that is intermediate amount, not commercial.
Why then you were convicted for
And
what?
there is no 29.
my commercial.
They have convicted me 20C on the ground that they are saying that on my statement, the recovery from the other accused has been made.
Who is the other accused?
Other accused is my brother.
There.
Okay, how much?
38. They have
38
clubbed it.
kg. my lord.
38
No,
kg.
35 kg.
30.
They have clubbed this 1.180, 1.08.
Okay,
Yes,
that,
yes,
have
that
clubbed
is,
it.
that,
They
my lord,
clubbed
okay,
it.
that will be at the time of
he
hearing.
might be,
That will be at the time
yes,
of hearing.
he might be.
We
I don't-
presume it to be 37.
Yes,
Rigor is there.
Rigor,
Yes.
because
Okay.
my.
Let
my
us first proceed on
lord,
that.
if, na kiba ase di koi lagu maage
Not
lagu.
37 to,
I will-
what do you know? I'm sorry.
Okay.
So for that time being, we are not going to the that it is whether it's 37 will be
Yes.
applicable or not. We are
For
we are
that-
taking it to be 37 is applicable. Let him argue.
My two limbs of argument was there. One limb of argument was there that there is no foundation, no seizure has been made. Second limb of argument is this: because of absence of 29, I cannot be prosecuted and convicted under 20 B2C. 29 is not there. There's no 29. No question, no evidence of 29.
That is
Conspiracy.
what, my lord,
Okay.
he have a good case in the appeal, my lord, in the form of.
In your case, there is IA. His case, no, there is no IA. ISJ. Okay.
His case is, my lord, clear, my lord, because from him, my lord, the
Majorities.
measure, my lord, 35 kg has been recovered, my lord.
Yes.
Now your lordship may kindly come to my lord, section 37, my
Yes,
lord.
I'm at 37.
And the first is, my lord, is okay, my lord. One part is that PP has to be given opportunity that has been there, my lord. But next is that where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense, and that he is not likely to commit any offense while on bail, my lord. These are the this carries a very, my lord, value, my lord, because, my lord, these my lord, sections are inserted so that, my lord, courts should be, my lord, slow in granting, so that, my lord, courts should be slow in granting bail at the time of, my lord, in the cases of NDPS, my lord. That is why these sections are inserted, my lord. That is the intention. And why I'm my lord, saying so, my lord, the reasonable grounds for believing that he is not guilty. He is not guilty. That means, my lord, now, my lord, the situation is, and now
He is already held to be guilty.
held to be guilty, my lord. So, my lord, now the rigors are more before the conviction and after conviction, my lord. And this is not my words, my lord. This is been, my lord, established in a several vision, because I am not that wisdom, my lord. I have what I have learned, my lord. That has been spelled out by honorable apex court judges, my lord. Because before and after, there is a very line of difference, my lord. So you cannot say that now he is not guilty. Whether he will be my lord, at the time of, my lord, whether his appeal will be allowed or not, that is different, my lord. Now you cannot, my lord, lordship cannot say that he is not guilty. And for that, your lordship has to be, my lord, very, my lord, what your lordship has to be so, my lord, satisfied for that he will, their grounds are such that he will be acquitted. So the rigors, my lord, at this point will be above what has been at the time of trial.
There is no doubt about it.
So that is
In
one
fact,
part.
forget about NDPS. In case of IPC offenses,
IPC
after conviction,
Fiction.
bail will be standardly something different. Because already one is.
In IPC, there are no bar as like the section 37. Here, the intention of the legislation is clear, my lord. That is one part, my lord. And that's why I am objecting. Secondly, my lord, lordship may kindly come to section 32A of NDPS.
Yes.
32A, my lord.
Just a minute. Yes, 32A.
No suspension, remission, or commutation of in any sentence awarded under this act, notwithstanding anything contained in the Code of Criminal Procedure or any other law for the time being in force, but subject to the provisions of Section 33, no sentence awarded under this act shall be suspended or remitted or commuted. There is several minor bars that has been placed under this act. So now for giving the benefit of stay and for 389, my lord, so lordships has to be, my lord, the satisfaction of lordships be, degree will be more, my lord, that he will be not guilty and he is not guilty and he is likely to be acquitted, my lord. So that is why these sections are inserted, my lord, 32A, my lord. Now, my lord.
Yes.
Then, my lord, now another, my lord, aspect, lordship may kindly come to 35, my lord.
Yes.
Presumption of culpable
Culpable
mental state. Now, at the time of trial, my lord, when the learned trial court, well, whether it's bad or, my lord, not, my lord, that we are not deciding now, my lord. The learned session judge, my lord, while trying this case, has placed the burden on him, my lord. And the presumption of, asserting that presumption of culpable mental state is there at the time of trial, my lord. But he could not reverse his burden. And that is why, my lord, he is now convicted, my lord. Here also presumption is against Section 35 is also there, my lord. Presumption is against him, my lord. Again, my lord. Another is that, my lord, the lordship will find Section 54.
Section 54. Yes.
Section 54, my lord. Presumptions from possession of illicit articles in trials under this act. It may be presumed, unless and until the contrary is proved, that the accused has committed an offense under this act in respect of narcotic and psychotropic substance, opium, poppy, and another is apparatus especially designed. So, my presumption of possession of illicit articles has been now it is proved as per his judgment delivered, my lord.
Okay.
So under 54, so under, my lord, so under Section 37, under Section 32, under Section 35, and under Section 54, my lord, all the sections are now established as on today, my lord, as on today. If we are not going for the appeal, my lord, so then also your lordship has to, my lord, now the degree that is has to lordship satisfaction that your lordship has to draw, the degree will be much more than what it is before, my lord. When there is a at least there is a in criminal jurisprudence that he is not guilty before trial, my lord. Now, my lord, he is guilty. So it is to be guilty, and every section says, my lord, that it is against him, my lord. So, and now, my lord, if we go by the, my lord, if we go by the at least findings of what the evidence states, my lord, seizure states, my lord, seizure that from one, my lord, 1 point.
Yes, your argument is that after a full-length trial,
yes,
these are established.
Established, my lord.
Whether that is defect is material defect or not, can be a subject matter of
Only
the final argument.
Final argument, my lord.
But for the purpose of bail,
least, my lord.
not only 37, already there is a conviction.
Yes.
And all these are there. So therefore, at this stage, this cannot be a ground
This
for
cannot be a ground. And
for
also,
release
my
on
lord,
bail.
yes.
That can be considered at the time of hearing. That is a different issue.
And the judgments where the learned appeals court has delivered, my there also, my lord, in one cases I have seen 2 years, another 4 years, and more than that, my lord. In all these things, my lord, these aspects are, my lord, very much considered. My lord. So at this stage, my lord, without going to the, my lord, seizure and other evidence, because evidences will be, if a lordship goes to the evidences, I will also has to something to say, because that comes, my lord, when the evidences are there, whether it is bad or not, whether you have cross-examined, whether everything aspect has to see, my lord. And whether that also, my lord, whether sampling and other things, all these things will come, my lord. Now, at this stage, my lord, and 389, your lordship on 389. 389, my lord, when 389 is decided, my lord, at least, my lord. Now, at the time, I am not saying that any common appeal, my lord. In the special act, my lord, the law is that, my lord, 389 cannot be, my lord. But it can be, my lord, but there your lordship has to be more sure.
Standard will be much higher.
Much higher, my lord. That your lordship, then that is what a lordship perhaps, I don't know whether I could make your lordship
No, no, I
clear or
could
not, my lord.
understand. No.
Yes, my lord. That is what from the reading of this,
Yes.
I could gather, my lord. And regarding the, my lord, seizure list, my lord, at least, my lord, if we set it to be correct, my lord, at this point, my lord, then from one, it is 1.8 kgs, and from his, my lord, confession, my lord, another 35 kg has been, my lord, recovered, my lord, from him, my lord.
Probably other person.
And there, my lord, so, my lord, regarding the issue of possession as also conscious possession, my lord, constructive possession, my lord, constructive and my lord, conscious, my lord. Those two aspects has to be dealt with, my lord. And for that, the detailed hearing has to be required, whether the constructive possession is there or not. That cannot be decided at this stage. And for it can be decided, but we'll take a full length hearing, my lord. So, and the other witnesses, the witnesses so far, my lord, they are also, my lord, official witnesses, my lord. At this, why should you believe those?
You will
disbelieve
say, you
those
will
official
argue that because of the
And not going
official
on the-
witness, it cannot be discarded.
Yes, it has to be, my lord, it can be discarded, and the
It can be
satisfaction-
with a
doubted.
suspicion, you can proceed, but when it is unsecond, you
Unsecond.
cannot discard because
cannot-
only because he is a police
If
officer.
other things is proved, if other things are proved, we cannot discard
That
their evidence.
this is, you cannot say that this
Yes.
is the evidence we cannot at all rely
Yes.
because he is on the police.
Whether, we cannot.
If otherwise it
Yes,
is
yes.
admissible and otherwise
And,
it is
yes, an
affirmed.
honorable court also has to say that if there is any bias, you have to show the bias, man. In
So
the
that
at
will
the
be
time of trial.
that will be a matter of
Trial.
trial.
If-
Final argument.
Final argument, my lord. So at this stage, my lord, I have these preliminary objections regarding the granting of bail, my lord. And if the losses may like to go through one judgment, my lord.
Yes, of course.
There are several others also regarding the official witnesses, my lord. But here, my lord, this is my judgment is delivered, my lord, my lord, watch understood, my lord, and now, my lord, honorable CJ, my lord. Here, I have flag mark, my lord, just, I'm not reading because of the paucity of time. my lord.
Okay.
Your lordship may kindly come to 7, 8, 9, and 10. I have flag mark. Just I have very short judgment, your lordship can use within a.
Now, if your lordship just permits me, may I just give reply to
Yes, yes.
the address that has been made by the learned public prosecutor. First of all, I will take your lordship to the understanding and the intent
7,
of
8.
section. Oh, I'm sorry.
Mr.
I thought we have finished.
Court is reading. no?
Just a minute.
Lordship.
If the lordship is going to which para, my lord, may I read, my lord?
Yes.
Another, this is the in as regards, though it is not an NDPS case, as regards 389, the parameters laid down nothing for consideration of bail under 389 . I have marked the paragraphs.
Actually, I'm also relying on true judgment, but before that, I will take your lordship.
Just
Lordship.
let him election. Yes.
Now,
That's all.
Perhaps regarding any regarding official witness, whether it could be merely because the prosecution did not examine any official witnesses, whether it will be bad, independent witnesses.
That is not now.
If it is required,
Yes, give it to.
now
Yes.
lordship, I will take your lordship to page number 68. It is the cross-examination of the informant.
Page
Who conducted
68.
68, who conducted the search. I'll just take your lordship to some points, whether this witness can be
This
totally,
is cross-examination.
he can be relied upon. Lordship will kindly see, no seal was used in the authorization letter.
Where?
It is from 1, 2, 3, 4, 5, 6.
Page 68.
6. No seal was used in the authorization letter. Your lordship has kindly find it, lordship. Other points of law raised by my learned friend, I'm coming to that. But now I just want to show some limited evidences. Now, lordship will kindly see, I have mentioned the seized suspect ganja 1.18 gram in exhibit P3. No signature of accompanied police officers was obtained as seizure witness. If there were police officer, what was the requirement of calling 3, 4, and 5 in the police station and taking their signature? Now, your lordship will also kindly come. I have not mentioned the time of seizure. When I searched the house of accused Sanjit Goyari, then I found his wife, 2 minor children at his residence. I have not mentioned the total weight of the ganja which was recovered from the house of Sanjit Goyari.
Sanjeev is he.
He. Now, lordship will kindly come. I mentioned specifically the weight of each packets of ganja, in total 3 packets which were recovered from the house of Sanjit Gyari, 12.16 kg, 5 kg, 21.6 kg. I did not seize weighing measure. So this is the evidence, Lordship. Lordship may kindly see. The statement of Bonu Sargari was not recorded in presence of any witness. So how on my confessional witness they have gone to the house of Sanjit Gyari? There was no house of other person near the house of Sanjit Gyari. I did not verify the ownership of the house of Banu Sargari. It is not fact that nothing was recovered. This is the evidence. The Lordship may now kindly appreciate. Now, Lordship, I am coming to some judgments which I am relying. This is Amar Singh Ramji Bhai Barot. This is regarding. I'm just to save the time of the Honorable Court, I'm just giving the paragraph itself. This speaks of conspiracy, Lordship. The Barot's judgments.
Paragraph?
Paragraph 8, I'll just find it out for your Lordship. Lordship, may kindly have a look, Lordship.
Yes.
So, though it clearly speaks if there is no conspiracy, accused cannot be. There cannot be clubbing and there cannot be taken into consideration of the accused. Lordship, now I am coming to 54, which my brother just said. Sanjit Kumar Singh, alias Munna Kumar Singh, and State of Chhattisgarh. This is Supreme Court Lordship and kindly see. Recent most judgment 2022. I'm just finding out the paragraph for your Lordship. Paragraph number 33A. Lordship, may kindly have a look. 33A, Lordship. The Lordship was absolutely correct. But the very foundation, if 54 is to be attracted, the very foundation has to first come from the prosecution. Then only the burden shifts upon the accused. It's a not only for NDPS, it is for all case of criminal jurisprudence. It's very much clear to your Lordship. Now I am coming, Lordship, to what my brother said right now. To 32A. No suspension, remission, or commission in any sentence awarded under this Act. Now, Lordship will kindly see, here it is very clearly written, subject to the provision of Section 33. Lordship may kindly have a look in Section 32 what it is there. Nothing contained in Section 36.
Just a minute, Section
33.
33. Yes.
Lordship may kindly have a look, Lordship. Nothing contained in Section 360 of the Code of Criminal Procedure 1973 or in the Probation of Offenders Act 1958 shall apply to a person convicted of an offence under this Act unless such person is under the age of or that the offence for which such person is convicted is punishable under Section 26 or 27. That means 36 will come, 33A will come, Lordship, if I am punished under 26 or 27. If I am not punished under 26 and 27, then it will not come. Then 389 will come. And the parameters of 389 is very clear that if there is some merit in my appeal,
Yes.
so for 38,
Just correct it, my lord. What section says, my lord?
According to you, it will not be applicable when it is 26 and 27.
And
Otherwise, it will applicable. This is
yeah,
your.
yeah, my lord, that is
Yes.
what
Yes.
I think it's a
Yes.
different interpretation is given. my lord. 18 years and 26 and 27. Their exceptions are there.
They are the exceptions. According to you, when the person is
aged
aged below 18 years,
and
then this rigor will not come 32. According to you, when the conviction is under section 26 or 27,
then not.
this rigor will not come.
No, it is not. Now it is not.
so here
Yes.
I am also arguing the same line.
Yes.
Perhaps my brother did not catch me.
Yes.
I am saying that I have not been convicted under 26 and 27. Lordship. I have been convicted solely under 20B2C. That is the only section in which I have been convicted. Now, Lordship may kindly come. Just for a moment, I won't take much time, Sir Lordship.
Yes.
37, everybody has been speaking aloud of 37. Lordship, kindly have a look into the 37, the wordings of 37, particularly 37(2), where the public prosecutors opposes the application. The court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense. At which stage? Let us understand this. So for my understanding goes, Lordship. Not guilty of such offense. CRPC says when it is a session tribunal case, every case has to be opened when the prosecutor addresses the court and takes the court specifically to the evidences which he is going to prove. Now, on considering of those evidences, if the court finds that he is prima facie not guilty of any offense, is it possible, Lordship, in an NDPS case? Absolutely not possible, because NDPS case rests upon seizure. If there is a seizure from me, then everything goes. If there is no seizure, nothing goes. Then, Lordship will kindly see that second line, that he is not likely to commit any offense which while on bail. But this will not be applicable on me while I am treated as an under trial prisoner. I'm an UTP. So the question of bail doesn't arise. Now, whether this provision, Lordship, will be applicable at this stage, this has to be kindly looked into.
Yes. Yes. What is your case? Today time will not permit. Hard. Mr. Bhattacharya, learned counsel for the petitioner. He has completed his argument.
He also has same line of arguments regarding my lord. No, not his, my lord. My part will be same regarding his also. my lord.
I'll just add 2-3 points. One more line, just adding to, Lordship, just adding to one more line. My brother has argued, taking me on surprise, regarding the points of law, which were never raised by them in their objection. Never.
Place this matter for further hearing on Tuesday. Tuesday.
Tuesday, Lordship, can be on Monday, Lordship. Tuesday, there is some difficulties. So, Lordship, kindly.
Tuesday, my lord, Monday.
Wednesday. See today's situation. This is pre-vacation. That's why we are trying our level best.
Tuesday, it's all right.
Wednesday.
Wednesday.
Wednesday will give it a try. Only I will hear him. That's all. Your part is complete. His part is complete. We'll hear him only.
My lord, can you go on Thursday?
Thursday.
Thursday, my presence will not be
Not
required.
necessary.
I have some personal inconvenience.
Not necessary.
Diplomat.
You said you are to keep the judgments here.